Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in.
Good morning.
Good morning, everybody. I'm trying to get my ears. I can hear now. Welcome. I'm Ada K. We are waiting for the love affair murder trial of Monica Sementilli, where she is accused of unaliving her husband via hiring somebody to do it for her. And so we're waiting for that. But we got documents for the Karen Reed trial. We got docs, people. We got docs. So we're going to give me a second and I'll start sharing. That's why I popped on just a wee bit early, because I really wanted to share this with you, but I got to get it arranged. Okay. So we saw some of these one of these documents yesterday, but we're going to go through it. By the way, yesterday's winner was One Sunny Day. Oh, sunny day, one sunny day. You won yesterday's entry for the end of the month giveaway. Guys, we have one more day. So in order to get into the giveaway, you have to do the following, and I'll just put it in the banner. You subscribe, and when you do, put I sub in the comments. That will get you entries for the $50 giveaway. I say Starbucks, but if you don't like Starbucks, I'll get a different card for you. Hit the like button and put I liked in comments for 5 more entries. Become a member, get 5 additional entries at any level. Super chats of any kind or level will be 10 entries. And if you gift memberships, well, guess what? You and the gifted person will get entries. Hello, everybody. I gotta get the giveaway going today. I forgot about it. It's okay, it'll catch you. Y'all don't have to re-enter. We're good. Well, we've got some interesting stuff going on for the Karen Reed trial while we're waiting for Sementilli. So in that, we got the Commonwealth motion to impound. We've already seen that, so I'm not going to pop that up. But what I am going to pop up is we have respondent to the Norfolk County. Let me get it in big and for you as much as I can and get it centered. Respondent to the Norfolk County Superior Court petition for the writ of habeas corpus. Y'all. Good morning, Toxic. By the way, thank you so much, June, who got the membership. Let me go see. By the way, FYI, we've got a ton of documents that we're going to have to pay attention to because, well, let it download. There it is. I gotta pull out come on, obey me, obey me. Show my chats. How about my chats? Make them embiggened. There we go. Mandy D got the gift. Oh, that's wonderful. Both of you get additional entries. So this is the respondent Norfolk County Superior Court's opposition to the petition for the writ of habeas corpus. Okay, guys, here we go. July 24, the petitioner criminal trial Massachusetts State Court ended when the judge declared mistrial based on jury deadlock. The petitioner claims that the double jeopardy clause of the United States Constitution bar retrial on 2 of the 3 counts that she has faced. Well, I'm going to scooch because it's 29 pages. The claims were rejected on the merits of the Massachusetts Supreme Judicial Court, or the SJC. The petitioner filed a habeas corpus petition on pursuant blah, blah, blah. None of the petitioner's contentions is, let me read it over here. Let me move it. It's a little bigger. I'm getting up there. Is valid based on the habeas relief, particularly gives a factional finding in the proceedings below the SJC construction of the Massachusetts law, both of which were binding in this action. The trial judge exercised sound decision. This is what this is saying. In declaring a mistrial, and the petitioner was not acquitted of any charges. The petition should be denied. So here's the arguments, y'all. Procedural posture. But before I get any further with this, we've got one hell of a document that we're going to have to spend probably all of Saturday going through if I'm here. And that is 147 pages. And here's the title of the document. Defendant Karen Reed motion to dismiss for extraordinary governmental misconduct. They did it. I wonder when this was filed. Let me look at the date. And it says redacted version. So some of the stuff is redacted. And that sucks. That sucks. The redacted version. But there's a lot to read in between the lines. There's some redactions, but there are 147 pages. Well, it also includes copies of the affidavits and everything else, but I think there are 40 pages of actual content that we can go through. So we're going to dive into all of this. Don't worry. We're not going to miss a thing. So on the breaks, we're going to go through this. So while we're still broken, let's bring it back in. Let me get, there we go. Procedural posture. In 2022, grand jury returned 3 indictments against the petitioner, charged with 1, murder of second degree, manslaughter while operating a motor vehicle while under the influence of alcohol. This is the important one. This is the one. Good morning, Haley Mouse. Oh, sunny day. Hello, it's Brit. Good morning, June. And hello, Miss Toxic. By the way, I hate to interrupt, but I need to interrupt. I need to give a big shout out because I would not be reading any of these documents if it wasn't for As the Gavel Drops. So, if you'd like to have copies of these and read them at your leisure, go to Discord, enter into the As the Gavel Drops Discord page, register. Once you've registered, validate your account. And then you have access to all these documents and many more. Right now, they are covering over 500 different trials. Also, if you love to do research and would like to be a mod over there, please give Toxic Orchid a hello and see what happens. But thank you, thank you, thank you, thank you for all y'all's diligence and hard work because I couldn't do this if it wasn't for you. There you go. All right, let me get back on to this while we have time. I'm kind of talking fast because the court is already got the camera on the seal for Sementilli. But during breaks, we're going to be doing Karen Reed. So the manslaughter while operating a motor vehicle under the influence, that is the second charge. Now, if we listen to the actual juror that spoke about this, it was not this charge, but it was the lesser charge under this charge that they were stuck on. They were not stuck on manslaughter while operating the motor vehicle while under the influence of alcohol. They, per this juror's words, they, the jury, some of them, felt that she was operating, it's the point right here, operating a motor vehicle while under the influence. That is what they were struggling with, not manslaughter. They didn't feel she committed manslaughter. They just felt it was the operating a motor vehicle under the influence of alcohol, and that was a lesser under this charge, and that's what hung them. Okay? And the third charge was leaving the scene of a personal injury that resulted in a death. So, count 1, the manslaughter while charged with murder in the second degree and leaving the scene of personal injury or resulting in personal injury or death, those she was acquitted of. And they were only hung on the lesser than under this charge. So, anyway, a jury trial on 3 indictments began on April 2024. Lasted for almost 2 months. Oh my gosh, Tess, thank you for being a member for almost 2 months. Oh my gosh, you rock. You're so amazing. So, a jury trial on 3 indictments began in April of 2024, lasted for 2 months, July 1 of 24. The 5th day of deliberation, the trial judge declared mistrial based on jury deadlock. That is true, but that's not the problem. Here comes the problem. Following the mistrial, the petitioner filed a motion to dismiss counts 1 and 3 under the double jeopardy grounds or in the alternative to conduct a post-trial jury inquiry. Why? Because there were 2 affidavits that were written to her attorneys. The Commonwealth filed a writ of opposition to the motion, and the petitioner filed a replay. The petitioner also filed 3 subsequent memorandas, each accompanied by the affidavit of counsel. On August 9th of 2024, the trial judge heard the arguments on motion and the memorandum of decision, and the order entered in August 23rd, 2024 was denying of the motion. On 9/11/24, the petitioner filed a petition for extraordinary relief pursuant of Massachusetts General Law, Chapter 211, Section 3, seeking to review the order denying her motion to dismiss. Quickly scanning that. Okay, we know that. A single justice a single justice of the SJC reserved the report in the case without decision for determining for the full court. February 11th. So what does that mean? A single justice, one of the single SJC judges, reserved and reported the case without decision for determination of full court. February 11th of 25, the full SJC issued an opinion affirming the trial judge denial of petitioner's motion and remanding the case to single justice for entry of judgmental denying. So basically, the whole SJC decided with the judge, Canoni, and denied the petition. Here are the facts. The jury desk locked Tuesday, June 25th of 2024, 37th day of trial. The judge charged the jury. She instructed the jury on 3 indictments as well as 2 lessers included. Offenses of count 2, involuntary manslaughter and a motor vehicle homicide. Before deliberating began, the judge, let me read this. Before deliberating began, the judge indicated that the jury would be given separate verdict slips for each of the 3 indictments. She explained the jury procedures for delivering these verdicts. Well, guess what? That didn't happen. Of course not. After the final vote of the jury, the floor person should check the appropriate boxes. And this is the instruction. Okay, here we go. And by the way, the one jury that spoke to Turtle Boy said that this was confusing on their behalf. They said that they were greatly confused as to what and how to fill out these forms. I'm trying to get something organized on my screen. I forgot I needed some information. Let me see. Well, there we go. Okay, there we go. So after the final vote of the jury, the floor person should check the appropriate box as to each charge, then sign and date the verdict slip notifying the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom. Well, here's what the juror said. The way they read this was, if we did not come up right here, unanimous verdict on all 3 charges, they were not to fill out the form. That was their impression. So I was like, I can understand that. I can. Let me read again. After the final vote of the jury, the floor person should check the appropriate boxes as to each charge, sign and date the verdict slip, and notify the court that you've reached unanimous decision. So I can understand that. Now, if they had known they could put unanimous on 1 and 3 and hung on 2, he said they would have done that. She also instructed the jury to continue deliberating until you have reached a final verdict on each charge. Here we go. And do not disclose to anyone, including the judge, the numerical standing or procedure before such time as you have reached unanimous verdict. The jury began deliberating that same afternoon. Deliberations continued over the next 3 days. On Friday, June 28th, approximately 19 hours of deliberation, the floor person submitted a note that states, here's the note. Sorry. Okay, so by day 2, they had already reached a decision on counts 1 and 3. I'm writing to inform you on behalf of the jury that our that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Once again, they're thinking that they have to reach a unanimous verdict on all three of those charges or they don't reach one at all. They didn't understand that they can do a unanimous on one, unanimous on three, and not a unanimous on two. After reading the note into record, the judge requested argument for, and this is important, after reading the note into record, the judge requested argument from the parties on whether the jury had engaged in due and thorough deliberation. The Commonwealth argued that the jury had not had sufficient time to deliberate and that it was therefore too soon to give a Trudy Rodriguez, why can't I never remember that when I need it? Instruction. Okay. The defense disagreed and argued that the jury were communicating to the courts that they've exhausted all matter of compromise, all matter pursuant all manner of persuasion, and they are at an impasse. Well, let's read this in parentheses. Parentheses is always important. If a jury, after due and thorough deliberation, returned to the court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law application to the case, and send them out for further deliberation. But if they return, this is what a Trudy Rodriguez is. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent. Meaning they have to agree to go back in and continue unless they ask from the court some further explanation of the law. That didn't happen. So at this point, the judge determined that there had not yet been due and thorough deliberation given the length of the trial. The amount of evidence presented through 74 witnesses and 657 exhibits. Well, this is a lot. 74 witnesses, 657 exhibits. The complexity of the issues, the facts that each of the prior day deliberation had been shortened. She instructed the jury to continue deliberating. Now, that is a fair assessment in my humble opinion, because just that a day or two with that many exhibits, I'm struggling to think that they really, really went through it all. Deliberations extended through that Friday afternoon and resumed the following Monday morning. At around 10:45 a.m. on Monday, the jury foreperson submitted yet another note. Note number 2. Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by the fundamental differences of our opinions and state of mind. The divergence in our views are not rooted in the lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point to where consensus is unattainable. We recognize the weight of this admission and the implication it holds. Now, first of all, they are still hung on count 2. Count 1 and 3 have already been decided, per the conversation with Turtle Boy and one of the jurors. Upon receiving the note, this is important. The judge again invited argument on whether there had been due and thorough deliberation, although by this point the jury had already deliberated 24 to 25 hours. The Commonwealth argued it was still premature to conclude their deliberations had been due and thorough. Now, the defense counsel, however, maintained the jury had now come back twice, indicating essentially that they are hopelessly deadlocked. It was time for Trudy Rodriguez. They're asking for the Trudy Rodriguez. Okay? The defense, quit it. The defense again requested the Truy Rodriguez inter instruction. The judge determined that the jury had engaged in due and thorough deliberations, noting that the jury had been extraordinary and that she said she had never seen a note like this reporting to be an impasse. The judge did at that point give the Truy Rodriguez instruction and sent him back for further deliberation. Now, if they come back a third time, we're done. But it's how it was handled was the issue. About 2:30 that very same day, the floor person submitted yet another note, and this is an impressive note. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspective on the evidence are strikingly divided. Some members of the jury firmly believe, let me get this to highlight, it's easier for me to read. Come on. Firmly believe that the evidence surpasses the burden of proof, establishing the element of charge beyond a reasonable doubt. Controversially, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of charges. But is it count 1, 2, or 3, or all, or 2, or part, or what are you hung on? We won't know. The deep division is not due to lack of effort or diligence, but rather sincere adherence to our individual principles and moral convictions. Now, once again, hindsight's 2020. The juror that did come out and publicly speak said that they felt, and I'm paraphrasing, okay, I'm not giving word for word, but basically they felt that she was drinking and driving and thus deserves to be punished for something. Pretty much is what was said. To continue deliberating would be futile and only serve to force us to compromise these deep beliefs. We have jury. We're going to have to come back to that. I mean, we have court. I will put that on pause. When this court comes into any kind of break or recess, we will continue this. Continue this. It will be continued. Thank you guys for joining me for this wonderful day. Um, it is a glorious day today. I will have to confess, I did go it was a hard night. I mean, not hard, but it was a little bit difficult. I went to my, sister's husband's house, and we started going through some of her things, and, I stayed up late last night. I have brought some stuff back here to organize, and I stayed late and fell asleep. Slept here last night, y'all. Luckily, it's got up early enough. Court started late enough that I could go and, clean up and come back and all that wonderful stuff. But, I was grateful that court's starting at 11:30 my time today. So thank you so much for joining me. I may be yawning today, but I's here, y'all. I'm here. Okay. So Miss Sementilli, why are we frozen? Court is frozen. Let me see if I can restart it. It looks like they're frozen on their end. Well, they're frozen, so we'll continue. I'll continue reading until until okay. After yeah, it's still on. After the judge received the third note, this is the bone of contention. Parties returned to the courtroom. The case was called. The judge informed the counsel that the jury is at an impasse. The jury were called back to the courtroom. See, the third note was not read out loud into court record before the jury was brought into the courtroom. Before the jury was brought into the courtroom. And the person we love having you here, Tash. You are family. So the first two times the court was at an impasse, the jury was at an impasse, note was sent in. They were, the note was read into record before the defendant and the prosecution, and then the jury was brought in, and then they were sent back out. This time, they did not, because here's the thing. Had the note been read into record prior to bringing the jury in, the defense would have proper time to say, "Your Honor, may we consult with our client?" They would have had a discussion about this being an impasse and we did declared a mistrial, but that didn't happen. It was not afforded the defense is arguing it was not afforded an opportunity for them to object, and that's where we're at with this. So, 3rd, note was then, after the jury's brought back in, was then read aloud into record. Upon reaching the final line of the note, stating the further deliberation will force the jury to compromise their deeply held beliefs, the judge addressed the jury saying, "I'm not gonna do that to you folks," and declared a mistrial. Boom, 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 boom. We're done. You leave. No time for the defense to confer with their client and enter in an objection. Perfect place to stop. Trial is now starting in this imminent Sementilli trial. Day number 18.
8 photographs of the target lot with respect to cameras.
Very well.
Now, Miss Sementilli, for those who don't know, is being charged in the unaliving of her husband. She hired people to unalive him. Recap, I think this lady was on the stand yesterday. What's happened is that they have been dealing with the truck that Mr. Sementilli had or owned on lease. She took it back to the car dealership saying that telling one person that he'd been unalived in the truck and that she no longer wanted the vehicle because of the memories it held. However, we all know that he was not unalived in the truck, and in fact, um, he was unalived in the backyard. And so the problem with this is the um that day she did not turn in the truck. She was just figuring out what she owed, what would happen, just the financial side of this. She comes back a month later and deals with this woman and decides to turn in the truck, and the company decided to eat the last few payments and not make her pay them. But she then decided she wanted to get a new vehicle. She wanted a new lease on life. The first time she was there, she had that behavior that she normally does, the tearless cries, and was very upset. Then, when she came back a month later, she supposedly had money, and the insurance money came in, which it never did, and that she was wanting to get another vehicle. She ended up getting a Mustang GT. But what was interesting is she bought every single upsell that they could throw at her. The rims, the oil changes, all of the upsells, and over 6 grand of upsells on this vehicle, making it about $65,000 vehicle in the end, give or take a half a grand or a grand. It was either 65 or 66 or something like that grand on this vehicle. And so that's where we are now at in the testimony.
About the target parking lot and the fact
Now
that
we
you
have, I
announced
think, a
that
detective up on the
location,
stand.
on multiple days.
Yeah, we have detective.
Looking at what's now been marked as People's 214, and Your Honor, there's a number 2 in the right, lower left corner. Do you know what's depicted here?
Let me
Yes,
set this up for you.
that's,
So what's happening is that she went to Target during the time of the unaliving for an alibi. So we're sitting here at Target. They're showing where the cameras are, and they're talking about her movement and all of that good stuff. So let's get back to it.
within the red circles is just showing where the surveillance cameras are located on that portion of the front of the building, the target.
Showing you, I think you talked about this yesterday, 214 with the 3 in the lower left corner. You mentioned a camera that was facing the area where one would enter. What do we see here?
Yes, that's a camera that kind of covers that, I guess it would be the northeast corner of the building.
As well as the cameras we just looked at in 214, or at least one of them, number 2, orienting it from another angle as well as another camera facing the parking lot.
Correct.
Showing you People's 214 with a 4 in the lower left corner. Are these additional cameras on the front of the building facing the parking lot?
Yes, these are the cameras that will pick up the far end of the parking lot that runs adjacent to the freeway.
The one, the area where Robert Baker parked and backed in the rented silver Nissan Versa.
Correct.
Showing you People's 214, number 5. Is this showing some of these cameras at the front of the building facing, taken from a different perspective?
Correct.
Towards the direction from which Robert Baker would have walked into the store on January 23rd, 2017.
Yes, exactly.
Showing you People's 214 with a 6 in the lower left corner. Here we go. Can you tell us what we see here, starting with the photograph on the left?
This is going to capture the door when you enter the target, the front entrance.
The one on the left from backed out viewpoint, so you have some context, and a close-up in the one on the lower right corner.
That's correct.
Showing you People's 214, where there's a 7 in the lower left corner. Are these photographs taken from the back area of that lot facing the Target store?
Yes.
And to the right in the lower left corner, lower right corner.
Are these photos of the date of the murder or just photos?
I'm going to object to the speaking objection.
You're objecting as, this is assuming facts on evidence or things of that nature? So rule. You require proper examination.
Thank you.
Again, what do we see here in these 2 photographs, Detective?
This is just an overall of the parking lot, and I believe you were pointing out the area on the very right end of the photo, exactly where your pen is there. That is where you enter.
And just to the right of where the entrance is, that would be where that building is that we looked at yesterday, that had a white roof where the Payless store was located.
Correct.
Showing you People's 214, this photograph has a 9, Your Honor, in the lower left corner. Can you orient us as to what we're looking at here?
Sure. So this area here where you see the green, I guess it's a trash dumpster, it's hard to tell. That was the area that we saw where Baker pulls into when he repositions the Nissan Versa.
Looks like it's maybe
Maybe a storage or.
okay. And that was the area where we talked about there was a small pedestrian gate that leads you through into the shopping center adjacent to the Target parking lot, correct?
Correct.
And then what do we see to the left here? Yes.
This is, so if you went into that little pedestrian gate, you would come around, walk through that pedestrian gate, come out this area, or you could just walk along this sidewalk and through this driveway, and it takes you around to Ventura Boulevard.
Okay. Where the entrance is back into the Target parking lot.
Correct.
And this area here, where I'm pointing with my pen to the left, this is that other shopping center area that feeds into or from the Target parking lot, correct?
Yes.
And if one were to go through this shopping center, does that also lead you out onto, I think it's DeSoto there?
Yes, I believe you can exit either DeSoto or Ventura Boulevard.
Yes. Showing you People's 14, there's a 10 in the lower left corner, Your Honor. Can you describe for us what we see here?
This again is that area where we see the vehicle repark. And over here would have been in the previous photo where we saw that green, whatever it was, it's no longer there, but this is to illustrate the parking area.
Okay, the green storage container.
Yes, correct.
Okay, and this area here would feed you into that shopping center that we saw in the previous exhibit, People's 214, number 9.
Correct.
Now, at this point, I want to move back to the timeline and looking at what we see displayed this morning in the top right corner. Do you know what this is a notice of coming in on the defendant, Monica Sementilli's phone? This text message, what this relates to?
Again, this is a notification that she's receiving
Was that a
from
package or something?
her security system that her closet mirror is open.
That's key to that pass, the answer is yes or no.
Okay, and that comes in the text message at 2:03 in the afternoon, prior to the time that the defendant leaves her home.
That's correct.
Were you aware?
I apologize,
Your
guys.
review of
Timeline.
the interviews in this case that in the recording of the interview that took place on May 18th, 2017 at the defendant's home with Detective Parshall, Detective Gable, and Detective Tellis, that she indicated to them during the course of that interview that Fabio used the safe for various items, but she did not.
Yes.
Were you also aware that she told detectives?
I'm gonna check this is argumentative and already.
I have no idea. I haven't heard the question yet.
This judge does not like it when the objections come in the middle of a question or comment. Wait until that is done.
I believe it was during the Perkins operation when she was subsequent to her arrest on June 14th of 2017 that Detective Gable came to the cell door and mentioned that warrants were being served simultaneously at her home and Baker's and other locations, and she was asked about the code to the safe that she indicated that she never used the safe and she didn't know what the password was.
Yes.
All right.
And you believe in this case here.
Overruled.
our review of the various reports and evidence in this case, was the safe the area where the victim in this case, Fabio Sementilli, stored or kept his gold coins, which I believe was also testified to the other day when you were here by a witness, Sam Pulera.
Argumentative, Ms. Stacy,
Overruled.
Yes.
Thank you. All right. Now we're going to move on to the slide at 3:26 in the afternoon, where the defendant leaves her residence. And I want you to give us, when you look at the video and the timeline, how long it takes her to get to the area where the Ralph's Market would be, which is the corner of Ventura and Winnetka, I
Yes.
believe.
And Ms. Stacy, evidence leaving the residence going to the.
Overruled.
I'm sorry, going to the Target, but what I'm asking, again, I'm asking about the time period when she passes on the video, the Ralph's Market, again, at the corner of Winnetka and Ventura.
Yes, I understand. Okay, so we know through this video that she leaves the residence at 3:26 p.m. in the black Ford F-150 and travels down Oakdale.
We can move on to the next.
As she's driving, there's a series of 2 Viber messages between Monica Sementilli and Robert Baker. This is now the video that captures her sort of skirting around the traffic to go through the light at Winnetka, and it takes her just 2 minutes to get there.
So at this point, she's passed the Ralph's, which took 2 minutes to get there.
Correct.
And she is on her way to the Target lot.
Yes. We're seeing here just a minute after her passing the Ralph's, a text message from Monica to Robert Baker at 3:29, 41 seconds.
Okay.
And just a little under 2 minutes later, she enters, or we see Monica driving the black F-150 into the Target lot.
Now looking at the video, we saw the previous one where she was caught on video on her way to the location.
Argumentative, caught.
Sustained.
On video, captured on video, 3:29 44 seconds within the red circle
Yes.
at the center left area. Is that the black Ford F-150?
Yes.
And the purple area, is that the circle in the towards the center of this particular video? Is that the location of the Payless store?
Yes.
And the photograph or what's circled in green to the right in the center, is that the same area where Baker had reparked his vehicle and it still remains at the back of the lot?
Yes.
Okay. And is this her taking a right into the Target parking lot?
Yes.
Okay. and then taking a left towards the Payless.
That's
If you-
correct.
If you could back up just a few frames, please. Okay. Can you tell us what you see on the video, captured on the video at this point, in the purple circle?
Yes, if you really pay attention to that corner of that white building, when we talked about how the cameras were blurry, but you can see movement, and it's easily, at least it was easy for me to distinguish between the movement of a car and the movement of a person walking through the lot. If you pay attention to that corner, you can see the shadow of a person come from that corner and walk into the lot.
Now, when you went out to the Target parking lot, did you note that there was actually that area there has cars, but that that are parked, as we see along the diagonal area here?
Yes.
That when this the defendant's Ford F-150 comes around, that it actually stops in a lane of traffic.
Yes.
Slowly.
So this is all leading.
So,
Right there. Is that a figure?
Yes. Appears to be wearing dark clothing.
See that figure right there?
Yes.
Okay. Again there.
Yep.
Walking towards the vehicle.
That's correct.
And then the Ford F-150 stops.
And it's very hard to see, but you can see the movement of that shadow come around the front of the F-150.
And at that point, does it appear that the individual who we saw walking along as you're facing the Target store, the left side of the building where there's a walkway that feeds you from Ventura Boulevard, that the figure comes around the front of the vehicle to the front passenger side of the vehicle?
Yes.
Leading.
Dane?
Okay.
Untimely, Mr. Levine.
Tell me what you see.
You almost simultaneously as the F-150 nears that corner of the Payless, you see that figure come out of the corner of the Payless,
I
approach
thought
the car
Payless
as
was
it
no
comes to a
more.
stop.
Do they
The,
still have
the
Payless
figure
stores?
walks around the front of the F-150 to the passenger side of the vehicle.
I thought Payless was done, in my humble opinion.
And at that point, does the Ford F-150 then move forward and park?
Yes,
Is that what we're seeing here at 3:30 and 22 seconds?
that's correct.
And the figure is no longer there.
Right. You don't see the figure leave the area after the Ford F-150 reparks.
And then what do we see here happen with respect to where the Ford F-150 parks?
It parks on that very far corner. It's almost the last parking spot in that row at the very back of the lot. And it remains there for a little over 4 minutes.
Okay, let me ask you another question while we're stopped at this point. Just to the right of that red circle, where the defendant parked in the Ford F-150 to the rear of the Target lot, just to the right of that in the green circle, what do we see there?
That is indicating the location where the Robert Baker had repositioned the silver Nissan.
Okay. And what do we see here?
This is just orientating you to the green circle. That's that little alcove where Baker had repositioned the car, and the red circle is the F-150. It's just showing you the relationship to the parking lot and where they're both parked.
Okay. And then during that 4-minute period, when Baker's vehicle is at the back of the lot to the right and the defendant's vehicle is parked to the back of the lot just to the left of him, are there any Viber messages during that 4.5-minute period?
There are not.
Moving on to the time period between 3:34 and 3:42 in the afternoon on January 23rd of 2017. Looking at 3:34, what do we see here?
We're going to see after that 4.5 approximate time frame, Monica back out of that spot that she's parked into the rear of the lot and repark her F-150 a little closer to the entrance.
Why? Why would you do that? That doesn't make sense
So
to me.
we just kind of see slowly.
And is
car
Payless
moving
still
toward-
there? I thought Payless shoe stores were gone a long
towards
time
the
ago.
entrance to the target and repark.
Okay, and does this show us the, let's go back. In this slide here, does it show us the context of the location now where she's reparked towards the front of the target? It's sort of in the middle area, it looks like, of the lot, and with Baker's vehicle still there on the same area where he had reparked.
That's correct.
Okay. Now looking at 3:36 p.m., what do we see here?
That is Monica sending a Viber message to Robert Baker. Then 1 minute later, approximately 3 minutes after Monica reparks the F-150, we see the Robert Baker driving the silver Nissan exit the parking lot.
Y'all, if you ever want to commit a crime, you will never
His
get away
vehicle
with
at
it
that
with
point
the cameras that
drives
are out
away
there
from the
nowadays.
target location, and he's not seen at that location again after that.
That's correct.
What do we see here at 3:36 and 29 seconds?
This we're going to see the silver Nissan exiting the parking lot. If I recall correctly, he actually exits through that alternate exit that we were talking about.
Okay.
We don't have video of whether he travels on to DeSoto or Ventura after that.
And at that point,
Again, Your Honor, objection, conclusion to who's driving.
it's an inference reasonable to
So,
defendant.
excuse me, that's for argument, not for evidence. Sustain.
At this point, the vehicle
Oh,
drives
yes, sir, Your
towards
Honor.
as we talked about, the other shopping center that is to the left in this particular diagram, or behind the target parking lot.
Correct.
And at that point, there's no video that shows whether he traveled directly forward, which would be towards, is that DeSoto?
Yes.
or whether he takes a left and goes out to Ventura Boulevard, where I believe we see that marked on the diagram. Is that correct? It says Ventura Boulevard.
No, this is all speculation and argument.
The term he, I would refer to that as the vehicle proceed.
I'm talking about where it went or did not go.
Oh, overruled.
Is that correct, that the Ventura Boulevard is marked on the diagram there? It shows us if you were to turn left that you would hit Ventura Boulevard?
That's correct.
Okay. So at that point, there's no videotape, so we don't know which direction he traveled.
We don't know which direction the vehicle traveled.
All right. And now what do we see happen a half a minute later, 30 seconds later, even less than that, 3:37 and 56 seconds.
There is an outgoing call, and it's Monica calling Jessica, her daughter.
And is this while her vehicle is still parked in the Target parking lot, now has been reparked towards the center of the lot, towards the front of the building?
Yes.
Okay. And what do we see here at the same, approximately the same time, just a few minutes later, a few seconds later?
It's just the same information, that same call logging.
Okay.
Telephones are
And
not alive
what
anymore.
do
You
we
can't get
see
away with
here
anything if you have
at
your phone on you.
3:39.
So yeah, approximately 3 minutes after the F-150 is reparked, we will see Monica exit that vehicle and walk through the lot and into the Target.
And where the red circle is indicated with a white box on it, does this track her progress as she walks from the Ford F-150 towards the front of the store?
Yes.
And then at this point here, 3:39, in about 10 seconds, do we lose sight of her?
We lose
Which
sight,
was-
very,
yes.
very quickly lose sight, and then pick it back up a few seconds later. This interior camera catches her actually inside the store now.
How can
At that
anyone,
point, do we
knowing
lose
that
sight of her?
that the
in the store?
husband is getting
Yes.
ready to be unalived, go shopping and be so calm? I
Actually,
couldn't do that.
then she pops back into frame, and she's got her cart and walks towards do her shopping.
Okay.
And then we do lose sight until she exits.
I can't do that. I don't know how she can do it either.
All right. And then what do we, oops. What do we see happen now after she enters the store at 3:40 p.m.?
Monica sends a text message, instant message to Jessica, her daughter, reminding her, don't be late for babysitting.
And again, at this point, she's using regular communication, so we have the content. Is that correct? That's how you know it says don't be late for babysitting?
That's correct. And we know based on the information that Jessica at this point hasn't left the Sementilli residence. She's still there along with Fabio.
And they're the only two in the residence at that point as depicted in the top left corner.
Correct.
All right. And what do we see here at 3:41?
This is the response from Jessica to Monica. I won't, LOL, laugh out loud.
And what is the next thing that we see happen at 3:47?
So we'll see Jessica leaving the Sementilli residence. She pulls out of the resident driveway, makes that same exit path on Queen Victoria to Oakdale. And here she is driving the red convertible Mustang.
Same vehicle we saw yesterday that she drove with her mother to the LA Fitness.
Correct.
Okay. So now at this point, Fabio is he home alone? There's no one else in the residence besides him?
He's home alone.
Okay. And this is just a couple minutes after the defendant messaged Jessica not to be late.
Correct.
Okay. What's the next event that we see?
So this is Monica's cell phone activating that IDMSS light app system, which we know is that surveillance system that plugs directly into the IP address of the Sementilli residence. And that's at 3:53 and 57 seconds.
So about 6 minutes after, 12 minutes after she contacted her daughter not to be late, and about 6 minutes after Jessica leaves, the defendant connects to the application to view her home surveillance cameras.
Yes.
Okay.
How sick can you be to watch it on a surveillance camera?
There's also one time left over.
And what do we see next?
Oh,
During this
This is
period from
timeline.
4
Real good
p.m.
timeline.
to about 4:15 p.m., Monica's cell phone connects with the IP address to the Sementilli residence 8 times.
Why? See, that's unusual. Now, I have our Ring app. I mean, our surveillance. Let me put it here, right here,
And this indicates
and up
the
there.
distance
so I can
between
see customers.
the target and
I have one at home.
Sementilli
I'm not
residence
sitting there watching
Yes,
it.
at 2 miles.
yes, it
Creepy.
is. 2
Does that
miles.
appear to be consistent with what you know it to
Creepy as
be?
hell, man.
Yeah, I believe it's almost
Saying.
exactly 2 miles from the Sementilli residence to the target.
Well, that calls for conclusion depending on the rapid.
And what is the next event that we see here at 4:18 p.m.?
This is the video that depicts Robert Baker and Christopher Austin running up Oakdale towards the Sementilli residence.
And this is at
I believe it was 4:18.
4:18 p.m.
Correct. 4:18 p.m. Of course, their faces are covered, and they've taken measures to not be recognized, obviously. We see 'em-
Faces are covered, hands are covered.
yeah, and when face is like completely covered, you can't see even anything other than the nose area. They round the corner and run up Queen Victoria, which would be towards the Sementilli residence.
Okay. So what is the next event?
Incoming call To Monica from her daughter Isabella, and that's at 4:22 with 9 seconds.
And yesterday, I believe we saw that at 1:40 on this date, the defendant messaged Bella to let her know when she was on her way home.
Yes.
Okay.
See, do you know what's so sick about this?
And
He
almost
waited.
simultaneous with the incoming call.
It is alleged at this point that Monica waited for her daughter to come home and find her father unalive before she went home and entered the house. I'm like, this is a sadist. I can't say it. She's a sick woman. I cannot imagine sitting there knowing my child was going to come in to the home and find their father red-rummed and in that horrible condition that would traumatize and scar that poor child for life. You have to be a pretty sick woman. I am gobsmacked that she laid in wait for her daughter to find the husband. She didn't have the gall to do it herself.
Call from Bella to the defendant. What do we see?
Total.
This is it's just the cell phone, sometimes the records come in this way and it almost double captures the call. I believe, it's my opinion, that this is the same call, just recorded 2 seconds later.
No foundation.
Overruled.
Okay. What's the next thing that we see?
This is Monica Sementilli placing an outgoing call to Isabella about 2 minutes after the incoming call from Isabella.
And then what do we see at 4:27? 3 minutes after
Monica,
she completes the call.
I'm sorry.
Go ahead.
Monica receiving an incoming call from Joseph Cohen, OD.
And do you know who that is?
I believe it's a dentist, her dentist, I believe.
Could that be?
Or eye doctor. I'm sorry, eye doctor. Sorry.
And with respect to, again, your review of the evidence in this case, as we will see, was Bella after school. I think we talked about yesterday that she was going for an interview at a deli, and then after that was going to, as she told detectives in her interview, pick up a set of eyeglasses on her way home.
Correct.
Okay. And so at this point, at 4:27, after the defendant ends her call with Bella, the defendant then has a call from the eye doctor.
Yes.
Okay. And then what do we see after that incoming call?
Monica places an outgoing call to the same eye doctor.
Okay. Would that be consistent with being on the call with Isabella when a call is coming in from the eye doctor, missing the call from the eye doctor, or switching over to the call from the eye doctor, or calling that eye doctor back?
Objection, leading speculation.
Staying on the second row.
From your review of the records, the CDRs, was it consistent with the defendant being on the phone with Isabella and then calling back the eye doctor.
Same objection, that's what.
Yes, it's consistent with missing a call and calling that person back.
Okay. And let's look at the next event. And this is occurring while the defendant is inside the Target store, correct?
Yes, these calls occurred while she was inside the Target.
Okay. At 4:32, a few minutes after that call, what do we see captured on video?
This is a video that captures Monica Sementilli exiting the Target, and as she's exiting, she's staring into her cell phone, using her cell phone, and seems
Using her cell phone.
So overruled.
and seems to be preoccupied in her cell phone and almost miss the exit to the Target.
Objection, that's argument.
Is that what we see right here?
So overruled.
Yes,
She has to redirect herself.
correct. And still looking at the cell phone as she exits Target.
Looking at the exterior surveillance video now at 4:32, what do we see here?
This will just follow Monica as she walks out of the Target, through the parking lot, and back to the F-150.
And what do we see here at 4:37?
Monica places an outgoing call to her daughter, Isabella.
And next? What do we see here at 4:38?
At
1
4
minute after that call.
Yes, at 4:38, we'll see video that depicts the Ford F-150 exiting the Target lot. She backs out, actually comes the opposite direction of the direction when she arrived. Now she's the F-150 is stopped waiting for the traffic light.
At Ventura.
At Ventura, she negotiates a left-hand turn and travels down eastbound Ventura Boulevard.
Okay. What do we see here at 4:41 and 55 seconds, close to 4:42?
This is video that was captured in the Ralph's parking lot that's located on the southeast corner of Winnetka and Ventura Boulevard. And it will show the F-150 pulling into that Ralph's parking lot. The street
that
where
where
you see the
the-
bus there, that is Winnetka. So she's traveling southbound on Winnetka and actually enters one of the farthest entrances to that lot.
Passes several.
I believe there's at least one that you would pass.
And what do we see here at 4:42?
This is a sort of a closer video that captures the F-150, and it's going to travel through the parking lot and then park.
What's the next thing that we see here at 4:42? Bless you.
Yeah, a little less than a minute later, the entrance to the Ralph's supermarket, there's a surveillance camera there that captures Monica entering the market. She's pushing a cart, enters the market.
Okay, moving on to the 4:45 timeline. At this point, we obviously know, because we haven't seen any video of him leaving, that Fabio is on the back patio and that Baker and Austin are still at the location.
Correct.
And what do we see here happening at 4:46 after the defendant entered the Ralph's Market?
This is a Viber message from Monica to Robert Baker.
What do we see at 4:52?
This video will depict Monica exiting the the Ralph's supermarket. I noted that she no longer has the cart. She's just carrying a bag out of the store.
Small bag
Small bag, correct.
in her right hand.
That's correct. And looks like some sort of a purse from her left.
Wallet. Somebody asked why I'm not commenting as
And-
much.
One
I
moment.
used to talk a lot during the trials, but I'm really wanting you guys to get this timeline down. This is a very tight timeline. I'm impressed with this timeline. I've seen some timelines before, even in my husband's case. I thought that was impressive, but this is really impressing me. Technology, you can't get away with stuff anymore. With the way technology is, I can't imagine trying to do what she did and thinking that one can get away with it, because I got to say, this is tight and it's beautifully done.
And after 1 minute after she exits
couldn't
the
ask for
Ralph's,
Your timeline
what do we see here at
vital
4:53?
in cases like this.
We're going to see Fabio Sementilli's Porsche, black Porsche, driven by Baker with Austin in the passenger seat, travel down Queen Victoria and make that right-hand turn down Oakdale. This cutout of that is just to illustrate that there are two persons in the vehicle, and the one driving is wearing the green shirt and the passenger is in a dark colored hoodie.
And based on the DNA evidence in this case, obviously that Baker's DNA was found in the driver's compartment as well as on the steering wheel.
Correct.
And 1 minute after Baker drove away with Austin in victim Fabio Sementilli's Porsche, what do we see happening at 4:54?
Isabella Sementilli returns home. We'll see her negotiate that left-hand turn from Oakdale onto Queen Victoria. And this is her driving that red Fiat.
2 minutes after that, at 4:56, what do we see?
We're gonna see that same camera at the Ralphs, in the area of the Ralphs there, capture the Porsche traveling down Winnetka towards Ventura Boulevard. So there we see the Porsche, obviously with the green circle around it, traveling towards Ventura Boulevard.
So the opposite direction that we saw the defendant travel when she was southbound from the Target to the Ralphs.
Correct.
And what is the next event that we see occurring at 5:03 p.m. on the date that Fabio Sementilli was killed?
Yeah, this is approximately 10 minutes after Monica, after we see her exiting that Ralph. We're going to see the black F-150 traveling up Oakdale and make that left-hand turn onto Queen Victoria. And that is when Monica arrives home from Ralph's.
Now, what I said about Monica laying in wait, that was brought up, I think, in opening statement. This is the first trial I've ever seen that took a day and a half for the prosecution to do opening
At
statements.
5:14,
But we do know the daughter did find the father.
in the late afternoon, what do we see here?
This is a Viber message from Robert Baker to Monica Sementilli.
And then just a few seconds later, we see that there's an incoming call to Baker.
Yes, Baker receives an incoming call from an individual in his contacts named Lashane Holmes.
And did his name come up during the course of your investigation?
Yes, it did.
And was he someone that you looked at, which we'll talk about a little bit later, as a potential third-party suspect in this case?
Yes.
And did you at some point exclude him because of certain evidence that you uncovered?
Yes, we, through our investigation, I determined that during the time of the crime, Lashane Holmes had an active parole ankle bracelet that had a GPS. And
Hard to knock
we
that.
contacted parole and learned that that basically the GPS showed him at home in the Orange County area at the time of the murder.
You
Was
can't
he
argue that, boo.
also another location where after the murder, besides Roger Brown at 331 Salem in Glendale, where he was observed by G&D and SIS surveillance crews, Al Birdsong's in Las Vegas, another Sheila and Ricardo Cabrera in the San Fernando Valley. Was this yet another location where Baker stayed for a period of time surrounding the murder?
Yes.
Connection leading speculation with foundation.
Sustained.
Did you uncover evidence that Baker also stayed for a period of time, 1 or 2 nights, with Lashane Holmes?
Yes.
If I could have a moment. All right.
We also learned a
Now,
lot yesterday.
looking at moving forward in our timeline on January 23rd to 9:20 p.m. From a video on Khalifa Street. Can you describe what we see here?
This is a surveillance system that was attached to one of the residents in this area on Khalifa Street, which captures an individual parking and abandoning the Fabio's stolen Porsche.
Now, we talked about
Oh.
this location yesterday. Approximately how far is Khalifa from Baker's residence at the time, 6817 Independence?
It's I didn't map that out, but I know the area. I would say that it's several miles, 4 or 5 miles probably.
4 to 5.
I'm gonna object, this is pure speculation.
So overruled based on this witness's testimony.
This Khalifa location, do you know, again, approximately how far it is from the Sementilli residence on Queen Victoria?
I would say it's at least 5 miles as well. The Khalifa the area where the car was abandoned is it's not like heavily the houses are big, the properties are larger, so there's not a lot of pedestrian traffic. There's not a lot of traffic at all. It's
Residential.
it feels
You guys, nobody in their right mind is going to dump a Porsche. If anything, what will they do? They will take it to a hack shop. It will be sliced and diced and sold for parts. It will be it would be disassembled within a day and it would be gone. I mean, nobody is going to, in their right mind, steal a Porsche, a car of that caliber, and just park it somewhere and walk away. That is not how it's done. Just saying.
like rural residential when you go to that area, actually.
They take it to a chop shop, especially in that area. There's chop shop.
All right. Now I want to move on and ask you some other questions. We saw that it took the defendant 10 minutes to return home from the Ralph's Market on the day of the murder. On any of the occasions where you drove that route during the same time period that the defendant did, from the Ralph's location back to the residence, did it ever take you 10 minutes?
Never.
In terms of the LA Fitness video, I know we talked about some of the video times being off and that they were corrected within the course of the creation of the PowerPoint timeline. Did you note that the LA Fitness video was off by an hour and 43 minutes?
Yes, that was noted. And in terms of this timeline, everything that's been depicted to the jury and to the court has been adjusted to the correct time that was verified through finding the differences in the video and also through the cell phone records and other records in the case.
I
you
wish I could zoom.
count the number of Viber messages between the defendant and Baker on the date of January 23rd of 2017?
I did.
What was that number?
I have so many numbers now. I'm trying to, I believe it was,
Yeah, that's true.
Is it
Can you look at your
approximately
notes,
180?
please?
I'm gonna check on this speculation.
Would it help to look at your notes? Yes.
I'm sorry, the time period again?
On the day of the murder,
On the-
starting only, so I'm not talking about, I'm excluding any messages during midnight to 6 a.m.,
Right.
counting in, as depicted in our timeline, during the 6 o'clock hour, we saw
Yeah.
that Viber message from the defendant to Baker, excluding that until that communication, that message from Baker to the defendant at 5:14 p.m. That was the last communication of the day, correct?
Not only was that the last communication of the day, but the Viber accounts were deactivated by both Robert Baker and Monica Sementilli on that day.
And after that date, they began using a different encrypted application to communicate, correct?
Correct.
And which one was that?
That was WhatsApp.
And approximately how many Viber communications were there with respect to the timeline that we showed between the 6 a.m. hour, again, excluding anything from midnight to 6 a.m., just 6 a.m. until that last communication at 5:14 p.m.?
I would have to refer to my notes. I want to say that it was 95.
I'm gonna check you on it.
I mean,
Would it help to refer to your notes?
I have the numbers actually that I stored on my cell phone. I couldn't find it.
That's good enough. Go ahead.
We need a little time.
All right, let's take our morning recess now for 15 minutes. The other supplies. See you back here in 15 minutes.
Yay! Good timing. Great timing. Because now we're going to go back into the Karen Reed document. Dum, dum, da, da, dum, da, da, dum, da, da, dum, 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 dum. I got to get 2 more stitches in. Then we can read. That's 1 and 2. Somebody asked what I was doing. For those of you who are new to the channel or don't know why my hands are feverishly pedaling underneath the TV monitors, I make Native American regalia and I have to bead a bunch of these. I am so far behind schedule, y'all. I've just got to get this done. There is powwow season's already going and flaring, and we've got local powwows that are going to be happening, and I got to get all this done. So with that, let's get back over to the Karen Reed document. Let me get back over here. Okay, so we were right here. The judge discharged the jury back to the deliberation room, explaining that she would meet them in privately to thank them for their service. The judge and the parties remained in the courtroom and scheduled a date to return for status conference. At no point during this discussion did the defense counsel object to the declaration of a mistrial or express disagreement with the outcome. This right here has been the problem. This right here is why they have lost every motion concerning this. And this here is why the JSC, I think it's Justice Supreme Court of Manassas, has not granted them anything because of that right there. So let's go back let's go back over here. A week later, on July 8th, the petitioner filed her motion to dismiss with the affidavits from her counsel, attorney Alan Jackson and David Yannetti. Attorney Jackson's affidavit stated that on July 2nd, a purported juror A contacted him. Unsolicited contact is very good. He said he would be able to identify which juror they were from the conversation with them. According to the Attorney Jackson's description of the conversation, Juror A said that the jury unanimously agreed that the petitioner was not guilty on count 1, murder in the second degree, and shortly following determined that they had unanimously agreed that she was not guilty on count 3, leaving the scene of personal injury resulting in death. So I'm going to highlight this and make it red. Well, no, we'll make that highlight green. Okay, that's important. Attorney Yeti affidavit stated that he had received communication from an informant both in July 3rd. He said one of these informant B, sent him a screenshot of informant B received from some other person, intermediary B, of a text message that intermediary B allegedly had received from a purported juror B. So someone sent a text to someone who sent a text to someone who sent it to the attorney. Hearsay, massively. Attorney Yeti believed he could confirm juror B had been deliberating juror based on the first name for juror B given to him by the informant B. According to the Attorney Yeti description of the screenshot, juror B allegedly text. This is the text. It was not guilty on second degree and split in half on the second charge. When the judge sent us back with that Hernandez thing, Rodriguez, to look at the other side, it turned into a bully match. Ooh, that's never good. When you have jurors turning into a bully match, this is never going to end well for the defendant. I thought the prosecution did not prove the case. Once again, no one thought she hit him on purpose or even thought that she hit him on purpose. That is a huge win for them. That is what they're going to have to start. That's what they're going to have to focus on for this case, second time around. Attorney Yeti stated that the other information from informant C had contacted him saying that they personally knew a purported juror C, as they and juror C used to work together and had mutual friends. Intermediary C. Hearsay again. Who current co-worker and friend of juror C. The informant C also knew from the intermediary C that juror C would be participating in a Zoom meeting with friends to discuss the trial. Okay, that to me is a little bit concerning. 3 days later, informant C sent Yannetti the screenshot of the text message exchange below. According to Yannetti, represented exchange text message said, no consideration for murder, 2 manslaughter, polling 6-6, and then deadlocked at 4 no's, 8 yeses. Informant C, if it was no consideration for murder 2, shouldn't she have asked, come on. Shouldn't she have been acquitted on that count and hung on the remaining charges? I'm going to put this as green for them. She should have been acquitted. I agree. Yes. The remaining charge where they were hung on. And this is just communication. I didn't ask to do that. I asked for something different. That. Thank you. Based on the descriptions, juror C by informant C, intermediary C, and Attorney Yeti said he could possibly identify Jury C, deliberating juror. On the 10th of July, Attorney Jackson submitted a supplemental affidavit stating that on the 8th of July, he was contacted by a purported juror D. And he said he was able to identify which juror they were from the conversation. According to Jackson, the description of the conversation, Juror D said, the jury unanimously agreed that petitioner was not guilty on counts 1 and 3 and disagreed was solely as to count 2 and its lesser. Very important because it is the lesser offense that and that was even said by the person that was interviewed by Turtle Boy. Attorney Jackson submitted a second supplement affidavit July 18th. He stated he had been contacted the day before on the 17th by the purported juror E. A, B, C, D, E. 1, 2, 3, 4, and 5. That's 5. This is number 5. He again said that he could identify the individual deliberating juror. According to Attorney Jackson, Juror E said the jury was unanimous, counts 1 and 3. There you go. Again, very consistent. Not guilty juror was deadlocked only on the lower charges on count 2. August 1st to 24, the Commonwealth filed in the trial court a notice disclosure that on July 21st, an unsolicited voicemail was left at the office phone for the trial prosecutors. I'm going to yellow that. The caller, who identified themselves as a juror by full name and seat number, stated it was true that what has come out recently about the jury being unanimous on counts 1 and 3. And the same individual left another solicited voicemail for prosecutor on the 26th, stating, can confirm the unanimous charges on 1 and 3, not guilty, and the 9-3 guilty on manslaughter charge on the lower manslaughter. So they don't know it's called lesser. It's a lesser charge. Again, they were hung on the lesser charge. I'm trying to figure out what that exactly. Wish I had the wording. I'll go back and find it. The Commonwealth notice further disclosed that it also had received emails from 3 individuals who identified themselves as jurors and wished to speak anonymously. So we did have more than just the 5 jurors. There's 3 more. The Commonwealth had responded to the emails by stating that although it would be welcome for the opportunity to discuss the evidence in the case, it was ethically prohibited from inquiring into the substance of the jury deliberations. It could not promise confidentiality, as it may be required to disclose any other communication to the defense in court. Stop it. Not what I asked. Again, let me get that back again. There we go. No. I'm sorry, guys. My mouse is feeling very squirrely right now. I'm going to make them pink. All 3 individuals declined to speak any further. That sucks, because that would have brought it to 8 out of the 12. On August 5th, Attorney Yeti submitted a supplemental affidavit stating that he had received an unsolicited phone call on July 31st. Caller said they'd been a juror in the case based on what they represented to Attorney Yeti to be their full name. Attorney Yeti stated he was able to confirm the caller was a person identified as Juror B in the affidavit. According to him, the caller said that the jury, again, here's the other, I'm going to go ahead and highlight, was again, indictments of 1 and 3 had been deadlocked only on 2. Once again, sorry guys, my mouse is being kind of squirrely. Nope, I want that one. Thank you. The caller also said that they were familiar with Attorney Yeti's prior affidavit, and the text message exchange reference in paragraph 4 of the affidavit's quote above was accurate. I'm going to do this in red. No one thought she hit him on purpose or even knew that she had hit him. So what they're thinking is, the jurors were kind of thinking was, do you know what? Oh, wait, the caller believed that other jurors had been reluctant to come forward because there was so much public media attention in the case. And that's fair. I'll put that in yellow. So, so what they were believing was that they didn't believe that she purposefully hit him, nor did she believe that she even knew that she hit him. The lesser of it was basically drinking while under the influence, which caused an accident or something like that. The pretrial challenge is governed by the general habeas provisions in 28 U.S.C. 2241, Section 2241. The First Circuit Section 2241 precedent instructs that to the extent of this petitioner may presently be in custody for the purpose of federal habeas relief, it is not pursuant to the Supreme Justice Court ruling, but rather it is because of any state imposed restrictions on her liberty while she is awaiting retrial. Yep. Judgment vacated on other grounds and or restrained. Petitioner is in custody due to personal recognizances, order pending pretrial, not SJC's judgment vacating require findings of not guilty in first trial and reinstating case for further proceedings before trial court. The petitioner is subject to such restrictions. So they're saying that this is normal restrictions and this is what she's going to have to deal with. She remains admitted to bail and must comply with certain pretrial conditions release applicable to the public in general. Dagnabbit. Glad that's there, but that's not what I'm needing. There we go. That suffices to meet the in custody. I did it again. Requirement. Petitioner released on personal recognizances pending retrial by itself was sufficient to deem him in custody under the Section 2241, given penalties described under Massachusetts law. If he fails to appear in court, it should be she fails to appear in court. That's not going to be a problem. She's so highly involved and she's so brilliantly smart. Having obtained reviews on the merits of her claim by SJC, she has exhausted her available state interlocutory remedies, and as her claim, it is one of double jeopardy based on the alleged successive prosecutions. Her restored to federal habeas corpus relief need not await retrial and conviction on 2 challenge indictments. I'm going to highlight that in pink for me to go back over. Standard of review. The review under Section 2241. The court must defer its SJC findings of fact, but must undertake preliminary review of the court's resolution of issues of law. In consisting its preliminary review, however, the court also is bound by must accept the SJC's interpretations of Massachusetts state law. We are similarly bound by the state court construction of its state status and issues of state law. Basically, they're just saying, we got to follow what they say. That's simple. Okay, we will restart this right here at the next break. Sementilli is back. Right now, we just watched basically the building of the timeline where she was, where the perpetrators were, in a very good organized manner. I was pleasantly surprised by the quality of timeline that they were able to lay down. You don't see that in a lot of trials. So kudos to you. Good job.
So
Don't know what they're waiting on. We can zoom a little.
Arbitrations took place between the defendant and Robert Baker from 6 a.m. on the 23rd until that last message from Baker to the defendant at 5:14 p.m.
Correct. 95.
Okay. Now, did you also look at the Viber business records that were obtained pursuant to a search warrant with respect to the number of communications between them using Viber the day previous on January 22nd, when there was an initial attempt to murder Fabio Sementilli?
Yeah.
What's his name?
On that date, January 22nd, did you determine how many communications there were using Viber between the defendant and Robert Baker?
Yes, there were 180.
Did you also review records and phone extractions for devices relevant to the defendant, Robert Baker, and Chris Austin?
I did.
And did you learn from your review of those records that the defendant registered and began using WhatsApp on January 27th of
Yeah.
2017?
Yes.
And that Robert Baker registered for WhatsApp, the encrypted app we talked about before we took our break, on the night of the murder, January 23rd.
Correct.
And that Mr. Austin, who we'll talk about later, registered and began use on January 29th of 2017.
That's correct.
In going through the timeline yesterday and today, we noted that through a security system called Digital Life that the defendant mentioned in her interview on May 18th of 2017 with Detective Gable, Parshall, and Verna about getting text messages every time her closet mirror opens, behind which was the safe. And we saw that there was a text at 2:03 prior to the time the defendant left to go to Target. Was there, during the time that Baker and Austin were in the home, any text generated indicating the mirror had been opened or the safe had been opened behind the mirror to the defendant's phone?
This is leading.
It's over.
No.
Oh, look at that smile. We have
Sidebar.
sidebar. We have a sidebar. This case is, I'm sorry to say it, moving so slow. And I know that a lot of viewers are like, but one thing I am appreciative of this case It may be moving slow, but it's moving appropriately. I appreciate the judge's running of the case. I appreciate the fact that the objections are being handled appropriately and we don't have fighting and bickering, although that's fun for us. But sometimes that can delay a court proceeding greatly. But yeah, with this, I just wish the evidence would present a little faster. That's all. Monday, even though there's trial, I will be doing a short day on Monday. I have to go to a meeting out of town, several hours away. So I will be leaving probably about 3 o'clock. Just FYI,
I did.
so you guys know.
And was there any text generated through that system during the period of time when Baker and Austin were inside the residence?
There was not.
This attorney is very slow. If I was the judge, I'd say, "Madam," she didn't
You
say,
actually created a timeline of the Viber communications for the day prior to the murder on January 22nd, correct?
Yes, I believe so.
and she's not at the podium,
Now,
which drives me
In
crazy.
the course of your investigation, did you also review evidence relating to travel by the defendant and Robert Baker after the murder?
Yes.
And did some of the evidence that you reviewed come from a cell phone extraction relating to the defendant, her iPhone? I think it was booked as LAPD evidence item under the DR as 119, an Apple iPhone 7.
Yes.
And did you also review evidence that came from Robert Baker's Dropbox?
I did.
Did you also review evidence that came from the defendant's iCloud account that backed up or connected to her Apple iPhone?
Yes.
And did you also review evidence, including photographs relating to an SD card that was found in the defendant's Ford Explorer, along with various items of women's clothing?
Yes.
Did you also review evidence of, along with photographs of the extraction from Baker's Samsung S8, which was booked as item 121?
I did.
showing you what was previously marked as exhibit. One 59, which contains 4 pages. Does this appear to be the timeline created from the use of the Viber records between the defendant and Mr. Baker on the date of January 22nd of 2017?
Yes.
And this was the date, as you testified, that there were approximately 180 Viber communications between them.
Correct.
Now, relating to travel, did you learn from your investigation as well as your review of the extractions from digital evidence that the defendant, along with Robert Baker, traveled to Las Vegas on 2 separate occasions?
Yes.
And do you know, did those trips occur one in March and one in May?
Correct.
And did you also view photographs and evidence relating to another trip that occurred at the end of May to another location?
Yes.
And where was that?
Myrtle Beach.
Showing you has been previously marked as Exhibit 117. Do you recognize what you see here?
Yes.
And what is this?
These are photos captured from 157 was an SD card.
That was the SD card I just asked you about a few moments ago that was found in Baker's vehicle, the Ford Expedition.
Yes. And of course, on the right, we have a picture of Monica Sementilli and Robert Baker, and on the left,
Wow, she has
it's Monica
definitely changed.
standing next to a big banner about the event.
No, I didn't see cumulative, it's already been shown.
I understand that, except the source is not, it's overruled.
Now, did you also find evidence relating to this trip in the defendant's email account?
Yes.
Your Honor, I have two sets of documents that contain emails, one relating to the date of March 10th of 2017. It is 4 pages in length. The other dated March 18th of 2017, it is 2 pages in length. And the final document appears to be a ticket to the Paradise Party compound. May these items be collectively marked as People's 215.
They may.
Thank you.
Okay.
Your Honor, I stand corrected. Thank you, Detective. The second set of emails is dated May 18th of 2017, the one that's 2 pages in length. 216, there is a number 4, 215. Okay, I wrote it wrong. Oh, you wrote it wrong. 215, thank you, Your Honor.
No
There
problem,
is
Miss Haley.
a
Now,
4 in the
every
lower left
minute.
corner.
This is not a hot trial. I get it.
Have you seen this before?
Yes,
And is this one of the items that you recovered from the defendant's email?
Yes.
Along with various documentation with respect to booking
Good.
airfare and this event?
yes,
Showing you the first page of the email from March 10th of 2017 from Expedia Travel. Can you tell us what we're looking at here?
The document speaks for itself.
Overruled.
it's an itinerary basically for the, flight, hotel for the time frame of May 25th to May 29th.
And at the very top of this email from Expedia, is it emailed to the defendant's email in her Hotmail account?
Yes, that is, the email for Monica Sementilli.
And if we move down to the itinerary, does it indicate flight from LAX on May 25th, round trip to Myrtle Beach with the price of $2,387 with an itinerary number?
Yes,
And does this document lay out the itinerary in terms of the airfare
Sorry, something's wigging out.
and the flights from Los Angeles to Charlotte, from Charlotte, South Carolina to Myrtle Beach?
yes,
As well as at the top of the third page, itinerary or confirmation number for the Sheridan Hotel at the Convention Center
yes,
under the defendant's name.
correct.
Showing you the second email from May 18th of 2017. Did you also note this with respect to your review of the defendant's email account from the defendant to an individual by the name of Tony Chubbs Marcus?
Yes,
And what does this relate to?
the pass, sort of like the pass to the weekend pass to the whole party event. Monica had, purchased 2 tickets and hadn't received them.
And is that what she indicates on the first couple lines here at the top of People's 215 help? Still have not received confirmation email for tickets.
Correct.
And then in response, is there an email saying that your confirmation has been sent?
Yes, resent.
Resent. I have an email from the Aria Sky Suites to the defendant dated July 18th of 2016. May this document be marked as People's Exhibit 216?
Yes.
Showing you People's 216. Do you recognize what you see here from the defendant's email account?
Yes, this is a forwarded itinerary of Fabio's travel to the Wella Professional Hair event in Las Vegas at the Aria.
In July of 2016?
Correct. And Monica forwarded it to Diane at Racquetball, which is a email address for Robert Baker.
And at the bottom of the second page of People's 216, does it contain a map that has, someone has written in pen an arrow with respect to the registration area and a path from the valet to that location at the casino level?
Yes.
And did that appear to match up to what has previously been marked 156 within Curtis Davis's PowerPoint with respect to a deleted email from the defendant's email account?
Yes.
Also showing you a document from Curtis Davis's PowerPoint, in this case 156, showing registration of a new Samsung S6 registered on January 23rd for WhatsApp, as we discussed a few moments ago. During the course of your investigation, did you ever recover a Samsung S6?
No.
Did you ever recover a flip phone relating to, oh, you know what, I'm going to come back to that. Oh. Your Honor, I had a set of 7 photographs that are photographs obtained from either Baker's Dropbox, his phone, or the defendant's phone, or from photographs from a search warrant. May they be marked collectively as People's 216?
217.
Showing you photographs from what was previously marked as People's 192. Did you find these photographs within Baker's Dropbox under a folder that was created under the name Monica?
Yes.
Looking at the center photo, do you know where this photograph was taken?
Yes.
Where is that?
This was in the underground parking area of the apartment complex where Robert Baker lived.
Showing you photographs contained in People's 217 that has a 6 in the lower left corner. Photographs from December 14th at from 2016 at 12:59 in the morning. Do you recognize what you see here?
Yes, I do.
And what do these photographs depict?
They depict Monica Sementilli with Robert Baker. In the photograph on the right, she's holding a cigar and they're smiling together. And on the left, they're kissing.
There is a continuing objection to the photograph.
Yes, I understand that, sir.
Did you find in Robert Baker's Dropbox numerous photographs that were sexually graphic in nature?
Yes.
Can you describe for us what those photographs depicted?
Objection, Your Honor, that's cumulative. It's open-ended.
Let me see his sidebar.
Whoa, we're going to read this. This just dropped. Thank you, as the gavel drops. This is an order of impoundment by the judge. The Supreme Judicial Court has recognized that the safety of the jurors is crucial to a fair, functional, and judicial system, and that the justice system owes them the highest degree of vigilance for the personal safety. This case has garnered significant and diversive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be daily subject to commentary on various social media platforms. People associated with this case have been charged with intimidation. Turtle Boy, did you know you were going to get in this one? I bet you did not. The court acknowledges that the names of the, hold on, I got to lock this in or I'm going to lose a ton of beads. Okay, the names of the impaneled jurors who rendered a verdict in a criminal case must be retained in the court files and made available to the public. Commonwealth, blah, 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 blah. The jury in this case did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. So, consequently, the court finds that good cause exists to impound the list of identifying names of impaneled jurors in this trial, in the trial of this cause. The court further concludes that there is a risk of immediate and reputable jury should the list be made available to the public at this time. See uniform. So, this order shall expire 10 days from the date of issue, unless otherwise ordered by the court for good cause shown and pursuant to the rule. So they've impounded it. So here are the copies of the notes that were sent to the judge in this case. So they're protected. Yay! I mean, I always think they should be protected unless they come up on their own. And that to me is very important. And I can respect that. I really do. respect that. What is this? In the 3 jury notes referenced above, the signatures have been redacted to protect the juror's identity in accordance with the Massachusetts Supreme Judicial Court ruling, and the trial judge order to impound the redaction appears on pages. So that's what this is. Okay. We just read it. So we got it twice. Is it 2 of the same? Wait a minute. Okay, the respondents. Uh-oh, I clicked the wrong thing. My bad. Let me get it back up here. Okay, this is 29 pages. We will read it, but this is the respondent, Norfolk County Superior Court's opposition to the petition for the writ of habeas corpus. We will look at that, you guys, in a wee bit. But we've got to get through the other one first in order to go to that one. Okay, let's go back to court. Thank you again. As the gavel drops, you were absolutely fabulous. No problem. Just I will keep on watching in my live communications from you or whoever. If you are dropping anything to me while I am live, whether you're a mod or a viewer in Discord, do so under live communication, because that is the only place that I will be able to, because that's what I have open. I mean, I can't be, I won't be notified of everything. So drop into live communications, then we can move them later. Okay. You were so awesome. Thank you. Back to the Sementilli trial. And why do we not have sound? Are we in another sidebar? We have no sound.
To,
Allow that.
Okay, they're still at sidebar. I'm speaking to all mods. Yes. Well, that's what I'm referring to. All mods, excuse me. If you were not a mod, put it in member chat and then let me know. But mods, I'm sorry, you're right, Miss Toxic. It is going to get a little bit crazy with documents surrounding this case, and I'm well aware of that. What the hell did I just do? I just did something stupid in my meeting. Yes, I apologize. All mods. Live communication. If I need to deal with anything, put it in live communication. Otherwise, put it in member chat and we will grab it. We too will get there. Okay, I guess she's looking at her phone.
Let us proceed, please.
let me try again.
Let's try it another way, boo.
Allow that.
Did you understand my last question?
I did, I don't remember.
Yeah, ain't that the truth?
Did you find numerous, when I say numerous,
Large quantity of.
over 240 photographs,
What kind?
videos, of a sexually graphic nature
PH
relating to
home.
the defendant and Robert Baker stored in Robert Baker's Dropbox under a couple different names.
Yes.
Was one of
Why do
those
women our
names
age do this? Women
Madonna?
can do it anyway.
Yes.
Don't send
And
me pictures of
another
yourself
one
to
named
men.
Real
Yeah.
Madonna.
Yes.
Can you describe for us? Let me ask you this: were the photographs of a sexually graphic or explicit nature ranging from 2016 to photographs in 2017?
Yes.
Can you give us a generalized description of what these photographs encompassed, Detective, based on your
Thank you, Haley Mouth.
sex crimes?
Yes. There was, as you stated previously, over 240 photos, mostly photos, some video, depicting Monica Baker. I'm sorry, I apologize. Monica Sementilli,
Oops.
partially clothed, completely nude, seductive poses. There were photos of close-ups of Monica Sementilli's vagina, close-ups of her breasts, close-ups of Robert Baker's penis. There were explicit photos of sexual intercourse, oral copulation.
Oh.
Monica is oral copulating
Oh.
Baker, oral copulation by Monica on other unknown males.
Oh my God.
Screenshots of Skype type videoing of Monica engaged in various sex acts with unknown male.
I don't want to get in trouble with YouTube, y'all. This woke me up. Population.
Masturbation, various photos of masturbation by Robert Baker, masturbation by
Just
Monica
forget it. I'm going to get
Sementilli,
demonetized. I'm done. I can't do it.
Of
Graphic.
close-up
Graphic.
pictures of an anus,
No.
close-up pictures of a finger in an anus.
I'm going to turn the volume off and read it.
Sort of posed pictures.
Just read it.
Partially clothed or nude in various locations, sort of like more nude modeling, I would say.
Oh my God, that
And
was my
when
favorite
you
word for today.
when you described some of these photos, could you tell from the background of the photographs where some of these photos were taken?
Yes.
Las Vegas.
And did some of those photographs take place in Robert Baker's apartment on Independence?
Yes.
And could you also tell that some of those photographs were actually taken in public late at night outside?
Yes.
Oh man, they're sick people. He was a Hone Star manager. I guess she wanted to be one. Oh my gosh. Yow. Yow. Up. Sorry about that. Please don't. I'm scanning to make sure we don't have some shown. Okay, I got a
217.
Pupper's comfort break. I'll be right back.
There is a 4, Your Honor, in the lower left corner for the record. Again, as we just discussed, were these some of the photographs as well as Skype that you located in Robert Baker's Dropbox under a folder titled Monica from various dates in 2016, including October and November?
Yes,
The still photograph that we see here on the left, is this what you were referring to when you said there were Skypes or videos of Skypes?
I was actually referring more to a screenshot of an actual sex act, and the bottom of that screenshot actually said Skype, so I knew that was Skype. This is obviously a screenshot from some sort of similar application where you can talk to somebody via video.
Okay, so this might be a video where a screenshot was taken from perhaps like FaceTime or something of that nature.
Correct.
Okay, and does this include in this photograph a picture of the defendant with Robert Baker?
Yes, and I can tell just by the background that Robert Baker is in his apartment.
And it actually, from that photograph, does it appear that he's not only in his apartment, but that he's in his bedroom?
Yes,
And you know that based on that something that you see in the background?
yes, that his chest of drawers and with the mirror.
Showing you what's been marked as People's 217 that has an 8 in the lower left corner, a photograph amongst the search warrant photos from the date of the arrest of June 14th of 2017. Can you tell us if you recognize what you see here?
This is Robert Baker's bedroom, and he has that very distinctive duvet or cover on his bed. And then that's the mirror that I talked about previously on the dresser drawers.
Showing you People's 217 that has a 9 in the lower left corner. Is
Hi,
this
this is
again a photograph
I am returning.
recovered
Oh my God, what's her name
from
called?
Robert Baker's
About the
Dropbox
yes.
under the folder Monica with metadata of the date of November 3rd, 2017 at 9:34 p.m.
Yes,
Looking at these, the photograph on the left, does the photograph to the right appear to be a close-up of some writing on the mirror above that dresser
This is
in
Rita Brown.
Robert Baker's bedroom?
it is.
Hi,
And what do
I'm
we
calling
see
again about the
here
American Sign
in
Language interpreting. I
these
have not been
photographs?
able to reach the managing company. They have not received.
So Monica is
Can you
looking
email
into
for
the
me?
mirror, I believe,
Spoke to you.
putting makeup
Okay,
on, and
Under
in
the ADA
upper
law, the
right-hand,
managing company
corner of the
not
mirror,
have
it says
to be a
Mrs.
part of this.
Baker, and then you
Number
can
one,
actually
I'm not
see
charging because I don't
Robert Baker captured in
church
the mirror
events. Number two,
taking the photograph.
I've interpreted for concerts for Sandy Patty and some of the bigger people with the glow and stuff. This is my specialty. And just so you know that I'm legit. And I have deaf
When
people
you
who have
observed
tickets.
the
They don't need
photograph
seating. They've already got their seating.
in the Dropbox folder,
But
it did not contain the black privacy box that we placed, correct?
Correct, her buttocks were exposed in the actual picture.
Showing you People's Exhibit 217, there's a 1 in the lower left corner. Do you recognize what you see here?
Yes,
And what is this?
this is two photographs of Monica Sementilli laying on Robert Baker's bed in Robert Baker's apartment, and she's wearing an Army t-shirt, which was given to her by Robert Baker.
Showing you what is now marked as People's 217. It has 2 in the lower left corner. I I can see that the photograph, as it appears here, is reversed. Do you recognize what you see here?
Yes, this is Monica when she's traveling home from the trip to Toronto to celebrate Fabio. She's in the picture on the right. I believe that's the first class lounge. She's having something to drink, and she's wearing that same army T-shirt. And then in the left-hand corner, she's in first class on the plane with I believe it's the menu.
And were these photographs recovered from cell phone extractions from her Apple iPhone, as we talked about earlier, number 119, and Baker's, one of his Samsungs, number 121?
Correct.
Looking at People's 217, hard to see. There's a 1 in the lower left corner. Do you recognize these photographs from, again, one of Baker's Samsungs, number 121, that were taken on June 6th of 2017?
Yes, this is at the depicting Monica playing pool at the Rabbit Hole Bar, which
Hey guys. Oh, hold on. I am so sorry about that, but I had to get on to, I may be interpreting the CC Wine in concert here in a couple of weeks, and I had to try to get a phone call in. So thank you so much. Hello, Dave. Hello, Haley Mouse. Everybody, welcome, welcome. This woman is a freaking idiot. I cannot believe she would put herself in the places and the positions she
if I
did.
remember correctly, is in West.
I wonder if
Hills.
she's an ex-addict.
Okay.
Just saying.
Now, with respect to the date of June 6th of 2017.
This woman's gross.
Later that night at approximately 11:30, were there also photos that were taken that you observed in the item number 121, Baker's Samsung, of the defendant posing in front of a new Mustang?
Yes.
And can you describe what was depicted in those photos?
It's probably 24 or so photos of I would describe them as modeling type photos that starts out sort of scantily clad with a long, I don't know if it's a long shirt or a dress. It's open, it's exposing partial parts of Monica Sementilli's either buttocks or breasts.
That's just gross, man.
And as the photos go on, she's no longer in the clothes. If I remember correctly, she's wearing very high heels and almost like leg warmers that go all the way up to the knee. It makes it look kind of like a boot, but it's actually a heel with a leg warmer. And in the latter photos, that's all she's sort of wearing. And she's posing in different sort of provocative poses, both next to the Mustang and up against.
That's why she wanted the Mustang.
Metal.
It's a tax write-off.
Like potentially a light pole?
Yes.
Now, some of the photographs that you found in these various devices or on these various devices were some of them taken while the defendant was on vacation prior to his murder with Fabio Sementilli.
Yes.
Were some of those photos taken in August of 2016 in Cabo San Lucas at a hotel called the Cape Hotel?
Yes.
And were some of those photographs taken on a trendsetter trip to Hawaii at the Kahala Hotel in October of 2016.
Yes.
Did you also find photographs of a graphic, explicit nature that were taken that one might describe as selfies while the defendant was in Toronto burying her husband?
Yes.
Were there also numerous naked or sexually graphic photos, as you've described them, of the defendant posing in her own home, either in her bedroom or lying on the couch in the family room area or posing in front of the dresser in her bedroom?
Yes, as well as some video.
Video with respect to sex acts, simulating sex acts or masturbation with various objects?
That is correct. Masturbation.
Did you also find photographs in these devices of the defendant drinking wine while cooking naked in Baker's apartment in the kitchen area?
Yes.
Some of these photographs that you found in Baker's Dropbox or on the extraction for the Samsung S8, the one device 121, were those also contained in the defendant's iCloud account?
Yes.
And did some of those appear to contain photographs of her lying naked while she was in Toronto visiting family in August of 2016?
Yes.
Did some of those photographs also contain various simulated acts of graphic nature involving, let's say, masturbation?
Yes.
And
How
did
can she
the
sit in
iCloud
court and listen to this?
backup belonging to the defendant also contain the photographs of her trips with her husband, such as to Mexico, Cabo San Lucas in 2016?
Yes.
Did also some of those photographs in her iCloud contain photographs, many photographs of her performing oral sex on Robert Baker inside of his Ford Expedition?
Yes.
With respect to the SD card,
I'm gonna object. This is far beyond anything
One moment. We can,
relevant to the murder
wait,
case.
one moment, counsel. We can approach.
Sidebar.
Yeah. This is going to be interesting. How can she sit there and not be totally red faced? Ooh, I'm just disgusted just thinking about it. Just saying. Y'all, I'm at loss of words. Was she an aspiring porn star? I don't want to put the P in front of it because it can get me in trouble, but they can say it. I'm probably already demonetized. But was that her aspiration in life? Was to be a slut? She's doing a good job of it.
In the lower left corner, there's a 9. The date on this one is actually 2016, is that correct? At
Correct.
9:30 PM, not 2017.
Correct.
The question I had just asked you was about the SD card number 157 found in the Ford Expedition belonging to Robert Baker, along with various items of clothing. Did those also contain some of the same type of sexually graphic photos that you've described during the time the defendant was in Toronto for her husband's funeral?
Yes.
I want to now move on to an area with respect to burner phones. Can you tell us, please, what is a burner phone?
Typically, it's a hard to trace phone, obtained usually for so that law enforcement can't link it to an individual. A lot of times,
No foundation, that's
Sustain.
Sure. What's your experience with burner phones?
I've had a lot of experience, unfortunately, with cases that I've worked where the suspect that I'm looking for has tried to elude or elude capture or get away with the crime by using a burner phone as opposed to a phone that's registered to that person.
And
And
how?
I've actually purchased burner phones to assist myself in an investigation, so that criminals don't know that I'm from the police department calling them.
So what do you mean when you say you've done it yourself? Tell us what that means. What have you done?
For example, I had a case where we were working with an informant, and the informant needed to make a series of phone calls for us. So we went into Walmart and purchased a prepaid cell phone with, I don't know, 200 minutes on it that is virtually untraceable. You don't have to give a name. All you do is pay for it. We paid for it in cash. So we didn't leave a trail of credit card, and there was no way to link that phone back to us.
So have you also handled cases where someone might purchase such a phone that's untraceable, where because they're paying cash up front for the minutes, so they don't need to purchase a plan, where they might use even fake names and addresses?
Yes, it's typically if you go into more of the traditional like Metro PCS or T-Mobile or things like that, you have to give some information. You have to give us information, a name, an address. You don't necessarily have to show ID, but you have to give information. And in those cases, what criminals have done to get around that is given fake information, fake names, fake addresses.
Did you find that that tactic was utilized in this case?
It was.
Okay. So I want to ask you, with respect to the evidence in this case, we heard that at the time of her arrest, the defendant in her Mustang on June 14th of 2017 in her purse was in possession of two phones, one the Apple iPhone 119 that we've talked about, the other being a ZTE flip phone that was booked into evidence under this DR number for this case on a property port number 120 that contained a cell phone number 747 250 0708. Did you uncover or investigate that particular phone along with a second phone?
Yes.
Can you tell us what you did and what you learned?
If I can, I want to say the date was January 29th. 2 cell phones were purchased at a T-Mobile, I believe it was a T-Mobile in Victorville off of Hook Avenue. One was the ZTE flip phone and another was an LG stylus phone. The individual who purchased the phone gave a fake name of Daniel Jones, correct, and a fictitious address that actually doesn't even exist, a fictitious city of Panama City, I think it was, Lindale Ave in Panama City.
Glendale Ave in Panama City?
I think it was Lindale,
Lindale.
Lindale.
Okay. And what else did you uncover?
We through a search warrant, I obtained cell phone records for both of those cell phones. And in relation to the LG phone, which was also a 747 number, I think it was 747880. I don't remember the last 4. In analyzing the CDRs for that phone, I realized that there were common contacts for Robert Baker in those phones, that phone was being used by Robert Baker as a burner phone, basically.
So once you obtained those cell phone records relating to these 2 phone numbers, you said that you noted that contacts relating to Robert Baker were contained on one or both of those phones.
One.
And which phone of the 2 was that?
That was the LG.
Okay. And did you uncover, based on those records, information relating to the ZTE phone, number 120, that was recovered, as I mentioned, in the defendant's Mustang on June 14th.
Yes.
Sorry.
Also,
She does hello it to Brit.
a search warrant
She's like,
obtain information
I didn't do that.
from T-Mobile regarding these 2 phones.
Yes.
Someone of her age acting that way is bad. I mean, at any age is bad, but that way, at that age, is worse.
The ZTE flip phone number 120, as well as the LG
I don't know.
phone from T-Mobile, and each
She's
of
just a hoe.
these items have photographs
In her humble
attached,
opinion.
one of which the ZTE has already been marked as 150. Could I have this set of documents and the additional photo marked as people's next in order?
218.
Thank you.
I'm appalled. I'm just, I'm appalled.
Showing you a document that's now been marked under this package for 218. Do you recognize what you see here?
Yes.
And what is this?
This is basically when when law enforcement writes a search warrant, this is one of the things that they provide along with or we request and is provided along with the CDR. And it's basically subscriber information. Who is the owner basically of that phone and that phone number.
And was this search warrant that references a DR number, is that DR number the DR number specific to this case?
Yes, it is.
And does it contain on this document here that I'm highlighting the phone number 747-888-2168?
Yes.
Were you also in court yesterday during the testimony of one of Robert Baker's friends, Roger Brown?
Yes.
Showing you what was marked yesterday as People's 212. Is that the same phone number that we see here that he testified to yesterday as a phone number provided him by Robert Baker after the murder, the 747-888-2168?
Yes.
And what does this document that we were talking about that you obtained pursuant to search warrant in Exhibit 218 indicate?
Gives the subscriber name, and again, this is just the name that was provided to T-Mobile.
Daniel Jones?
Daniel Jones. An address, the subscriber address as it was provided by the person that bought the phone. And
That
this-
was the Indale Street in Panama City that you said was a non-existent or a fake address?
Yes.
And does it also indicate just below the actual date?
Yes, and even sort of more importantly is that activation date on 1/29/2017.
What I just highlighted?
Correct.
Okay. And then beneath this, does it also indicate the same information with respect to the description or the phone model being an LG stylus?
Yes, gives all the identifying information for that specific device.
Showing you People's 218. There's a 3 in the lower left corner. Did you locate this photograph within item 121, the Samsung S8, a screenshot of this very phone taken June 3rd of 2017, that being the LG phone?
Yes, and unfortunately in this case, we never recovered the LG phone, but we did find evidence of it in a photograph recovered from Robert Baker's.
Which matched up to the search warrant information, correct?
Yes, it is an LG phone, and it appears to be the same in look and style as the LG Stylo 2 Plus.
Showing you the second document from T-Mobile within People's 218. Recognize what you see here.
Yes.
And what is this?
This is again, the subscriber information to, the ZTE phone. And it was acquired at the same place, on the same date with the same subscriber name and fictitious subscriber name and address.
So again, Daniel Jones at the same Panama City address, same activation date, correct?
Correct.
And here the phone number 747-250-0708, correct?
That's correct.
And you're telling us that that was the phone number for the ZTE flip phone that was recovered, that we see here depicted in People's 150.
Correct.
Did you also, let me just go back to that T-Mobile document. Does it also indicate phone model ZTE black?
Symbol, yes.
I'm sorry, I have to take a funny pause here. We listened to over an hour and a half of hyperventilating sounds coming from the back of the police car, and it actually sounded like a porn film. It did. If you couldn't tell the difference. I kid you not, it was disgusting.
Did you
That was not an easy
uncover
listen.
any information, given that you were able to
It was bad.
do a device extraction on the ZTE flip phone? Did you uncover any information
She's not a good
regarding the
actress, I'll put it that way.
use of that particular phone?
Yes.
And what was that?
It was used, not very often. I was not able to identify, any of the persons that were contacted in this phone. What was interesting to me about this phone was that on January 31st, when we know that Monica Sementilli traveled to Toronto, there is a information that was extracted from the actual device with a message that said, welcome to Canada. So the phone essentially switched from America cellular towers to cellular towers in Canada at the same time that we know that Monica Sementilli traveled to Canada.
And that would have been for the funeral.
Correct.
Your Honor, I have a 2-page document for the SMS messages relating to that ZTE. Could it be added to People's 218, please?
Sure.
Thank you. You recognize what you see here?
I do.
And what is this?
This was what I was speaking about in the highlighted portion. You'll see that it has that specific date, 1/31/2017, when we know that Monica traveled to Canada for Fabio's funeral. And there's the message, welcome to Canada.
Oh, it was
And here it says UTC -8, so
for
that
hours.
would be
That hurt.
California time, correct?
Correct.
But then when she
I'm
talked,
not sure because I didn't print out this document. We know through Celebrite, you can pick whether you want it in what time zone you want it in. I believe this is our time zone.
And this
And I
is,
believe it's already been sort of calculated for us, even though it says -8, I believe these are the actual times.
Okay.
I'm not certain.
it was, I can't breathe. It was hysterical. And then when she talked, she was fine.
had you also reviewed the recording relating to the Perkins operation, or the portion where, subsequent to her arrest, the defendant spoke to Detective Gable at the cell door at the Van Nuys station relating to this particular phone.
Yes.
And were you aware that the information that she provided was to Detective Gable, that she found that ZTE
It is
flip
hilarious
phone in the garage
in a
just
bad
prior to
way.
her trip to New York and Toronto in June of 2017, and that she was taking it to a store so that they could provide some information to her on whether it was an old phone and who it belonged to.
Yes.
So the evidence that you uncovered indicated that the defendant took that phone with her when she went to Toronto to accompany her husband's body back for burial in Canada in January, the end of January, January 31st.
Yes.
Mourning widow by day, hoe by night. I'm just saying. I'm just telling you what it looks like. Some people get mad at me if you want, but that's the way I see it.
Did you ever recover a burner phone that
I wouldn't be surprised
was
if they made a movie.
registered to Robert Baker that was a Samsung
Legal and illegal.
S6?
No.
Or clean and not clean.
As part of your review of the device extractions or cell phone data, did you locate within the defendant's Apple iPhone extraction text messages between her and her daughters subsequent to the murder of Fabio Sementilli?
Yes.
It's hilarious in a very bad way. It really was. And I wonder how she feels sitting where she is and her daughter's hearing that she's a hoe. I mean, what an example a mother is setting for her child. This just feels dirty.
I have two text
I mean-
messages between the defendant and her daughter Isabella that are dated April 21st of 2017.
And I think they're supporting her,
They
by the way.
marked as People's 219.
Yes.
Thank you.
I'll be right back.
Showing you People's 219, there's a number 27 in the lower left corner. Did you locate this information relating to a text message string between the defendant and her daughter Isabella or Bella on the date of April 21st of 2017 that began at 3:40 in the afternoon?
Yes.
And does this message indicate that the defendant was on Melrose shopping and that then she's going to go to dinner and karaoke?
Yes.
Well, I'm going to object on relevance grounds and no foundation.
No.
Looking at the second page where there's a 28 in the lower left corner, does that, again, indicate a response from her other daughter, Jessica, on the same date, now at 7:15 at night, asking where the defendant is, and she responds, Melrose, gonna have dinner, then karaoke.
Yes.
Showing what's been previously marked as Exhibit 194. This receipt from Melrose Avenue on the same date, April 21st, at 6:05 at night. Did you go through all of the evidence that was booked to this case under the DR number at Central Property on more than one occasion?
Well, I'm gonna check, there's no foundation. Speculation.
So room.
It's already in evidence. Is it, did you do that?
Yes.
And it's keyboard.
That's overruled. Council, I'm going to interrupt you. We'll take our lunch and recess until 1:30. The admission applies. Have a good lunch. I'll see you at 1:30.
Okay, guys, I'm back, and I know we're on break. Yes, we is. We's on break. Let me get my face up. So we are going to continue to talk about the Karen Reed documents that have launched. So the Karen Reed is going to be shooting a lot of stuff at us. So we've got a lot of documents to go through, and what I'll do is tonight I'll continue to go through these. I'm thinking about doing a night live just about these documents. Oh, that keeps making me think of the TV show Melrose Place, where they actually have a street in my town called Melrose Avenue. Yeah, I will be honest, it was an hour and a half of fake hyperventilating that sounded like she was in a horror film, and, it was very uncomfortable hour or so, hour and a half. It really, really was. So anyway, let's get back to this. We are now at point C. As a matter of federal ooh, can y'all see that? Yeah. Let me get some of this stuff out of the way. Get some of this stuff out. Okay. So we can read this. So thank you. Okay. As a matter of federal constitutional law, the trial judge exercised sound discretion in declaring mistrial based on the jury's deadlock. By the way, what are we reading? Some of you who are just joining me. What are we reading? We are reading the respondent Norfolk County Superior Court's opposition to the petition for the writ of habeas corpus. Yepers. So we're down here at C. See you next Tuesday. A mistrial premised upon a trial judge belief that the jury is unable to reach a verdict has been long considered a classic basis for proper mistrial. The posed no double jeopardy bar to retrial. Well, hello, Sensei. I don't cite all this. The decision to declare a mistrial because of the deadlocked jury is entrusted to the trial judge broad discretion and, according to great difference, to review case law. In the Rinco, the court reiterated that, end quote, the reason for allowing the trial judge to exercise broad discretions are especially compelling in the case involving a potentially deadlocked jury because, quote, the trial court is in the best position to assess all the factors which must be considered in making a necessary discretionary determination whether the jury will be able to reach a just verdict if it continues to deliberate. And, in absent such difference, trial judges might otherwise employ coercive means to break the apparent deadlock, therefore creating a significant risk that a verdict may result from pressure inherent in the situation rather in the considered judgment of all jurors. Let's go see the footnote. Footnote. Read footnotes. One of the first things you learn in law school, read footnotes. As noted by the SJC, the petitioner presented no claim below that the evidence adduced at her first trial was legally insufficient to support the conviction of any of the charges which would have precluded retrial, nor was the record she submitted on appeal adequate in any evidence to establish such a claim. She does not rise sufficiency claim in this petition. All righty then. Trial judges receive such discretion to avoid possibility of coercive measures being used to force a jury agreement, thereby protecting the fairness of the proceeding. In addition, notability for the purpose of this case, the court went on to reaffirm what is not required as a matter of federal constitutional law in exercising the broad discretion. I'm going to highlight this in green. No, light blue. We have expressly declined to require the mechanical application of any rigid formula when a trial judge decides whether the jury deadlocked warrants a mistrial. We have also explicitly held the trial judge declaring a mistrial is not required to make an explicit findings of manifest necessity, nor to articulate on the record all of the facts which inform the deliberated exercise of their discretion. It's a mouthful. And we have never required a trial judge there before declaring a mistrial based on a jury deadlock to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain consent of either prosecutor or defense counsel, to issue supplemental jury instructions, or to consider any other means breaking the impasse. So this is important, very important right here. I'm going to go ahead and do this. There we go. That's very important. In 1981, then Justice Rehnquist noted that this court had never overturned a trial court's declaration of a mistrial after a jury was unable to reach a verdict on the ground that the manifest necessity standards had not been met. The same is true today, 30 years later. Following the Renico and Bluford, if I'm saying it right, the First Circuit similarly, I can't say that word, has held that trial judges are not required to take specific steps or making specific findings and concluding the jury is deadlocked and unlikely to reach a verdict. So basically, they're saying the judge does not have to consult with the prosecution or the defense and does not have to consult with anyone if she believes they are at an impasse, and if her intervening will make this an unfair trial, then she can declare it. So under that law, under that case, they're saying they can't overturn her decision. But we have a huge document that we're going to read later that may say otherwise. Rather, a judge's exercise sound discretion to declare mistrial based on a deadlock so long as take some step to ensure the jury is truly unable to reach a verdict and discharge it. Clean, pure, and simple. That's it. There you go. There we go. That is the problem. Here, the trial judge is more satisfied this requirement. The jury's first note was delivered to the judge after approximately 19 hours, and our diligent consideration, 19 hours of deliberation over 4 days. In it, they stated, despite our exhaustive review of the evidence and diligent consideration and dispute of evidence, we have been unable to reach a unanimous verdict. The judge did not rush to declare mistrial. Instead, she heard from the parties, and even though the defense counsel argued the jury had already exhausted all matters of compromise in the manner of the persuasion. So this is going to hurt. I'm going to put this in red. This hurts the defense because they asked for a mistrial and that they were at an impasse. That is going to hurt the defense. The judge did not immediately declare mistrial. She took a measured approach of considering the extent of the jury's deliberation in the view of the trial length, the amount of evidence presented, and the complexity of the issues to be decided. She concluded that deliberations have not yet been due and thorough. She instructed the jury to continue deliberating. The jury deliberated another 5 to 6 hours spanning Friday afternoon and the following Monday morning before sending a second note, which notably more definitive. The second note, we find ourselves deeply divided in the fundamental differences of our opinions and state of mind. The divergence of our views are not rooted in the lack of understanding or ever, but deeply held convictions. And consensus is unattainable. Again, the judge did not race to declare mistrial. She once more gave the parties an opportunity to be heard. Defendant counsel argued the jury was, once again, here we are, hopelessly deadlocked. That is harmful to the defense. Still, the judge did not declare mistrial. Noting, despite the second note definitive language in the counsel's argument, judge still did not immediately conclude that all hope of attaining a verdict was lost. Instead, gave the Turi Rodriguez charge. After nearly 4 hours in additional deliberations, bringing a total of approximately 28 hours, the jury submitted a third note and even more emphatic. The third note stated, we conclude and find ourselves at an impasse. Our perspectives on the evidence is starkly divided, stemming from the secure adherence to our individual principles and moral convictions, and further deliberations would be futile and only serve to force a compromise these deeply held beliefs. I struggle with this. I really do, because, I mean, at the time of trial, you do with the information that you have. But since the trial, we had a juror get on and talk on the Turtle Boy show and said that what they were at an impasse as, or what they were struggling with was the fact that, yes, it was true. She had been drinking and driving that night. I'm going to add my footnote. So was every cop and everybody in that group. And some of them were more drunk than she was. I don't even know if she was drunk. But anyway, they were more of the mind that she should be held accountable for drinking and driving. They did not believe she hit him, and they did not believe that purposefully or knowingly hit him. So that's where I struggle with this, is because, but then again, none of this is known at the time of trial. So there's nothing that can be done about that. In her memorandum of declaration denying the petitioner's motions to dismiss, the trial judge explained, had no doubt based on the jury's notes at the court, the jury was unable to reach a unanimous verdict. A unanimous verdict is where I'm struggling, because there were 3 verdicts to choose. A, B, and C. There are 3, 1, 2, and 3. Count 1, manslaughter. Count 2. I can't remember that. Basically, drinking, driving, and hitting him and causing, and 3, leaving a victim to die. So, noting the juror's 3 notes, she found indicated agreement in any of the charges. So she didn't believe they could come to a verdict indicated on any of the charges or inkling of any kind of an agreement. I'm going to pink that. Despite the evidence, Kerr went into writing the notes on how articulately expressed the jurors' disagreements. It was also clear to the judge from the 3rd note that the juries would not consent to continuing their deliberation. Okay, that's fine, but they had 2 counts they had already decided on. At that point, the judge was precluded the Massachusetts law from ordering the jury to continue deliberations without their consent. The SJC likewise found that the jury clearly stated during deliberations that they would not reach a unanimous verdict on any of the charges and could not do so. Whoa! I don't know if I agree with that. I'm going to read that. The 1st and 2nd note provided indication of a partial census, and the 3rd note, which was repeated reference the charges, plainly implying the opposite. In short, the record before the trial judge suggested a complete deadlock. Not too sure about that. The trial judge took not just some step, but multiple steps to determine the jury was genuinely deadlocked before declaring mistrial. Both trial judge and the SJC found the jury was unable to reach verdict. The judge acted well within her broad discretion in declaring a mistrial. The petitioner's argument to the contrary proceeding and flawed premise pointing to the language of Washington that the burden of justifying mistrial rests upon the prosecution. She claimed the SJC improperly shifted the burden to her. Quoting Washington, ... the court went on to explain in Washington, however, that a deadlocked jury is the type of a manifest necessity sufficient to meet the burden. Indeed, it is the class basis for the proper mistrial. I'm going to see how much further this goes. Okay, I need to get a lunch. I need to get substance. So, what I'd like to do, and if it's okay with you guys, give me 10 minutes. We will come back to this in a 10-minute. I'm going to create a banner so people know. I got about 40 banners. Okay, we will be back shortly. That way I can take a comfort break, get me some food. My stomach is growling like a fiend. And it doesn't usually do that. So, and I'm getting a little shaky. So I think my blood sugar is getting a little low. So we're going to, yeah, we're only allowed 50 banners. I got 50. I got to go and clean them out. Okay, I'd better. All right. I'm going to put this back on this. I'm going to get us. Do y'all have a choice? Do you want country or do you want funk? Funk? We'll leave it on that. I'll be right back. Well, I got me some chicken. I like this song. This is kind of cool. I'm gonna drop it. Oh. Okay. Okay. Well, all right. So what we're gonna do is I'm gonna start reading again. I just had to take a little break, guys.
What's this?
Food.
Oh, thank you.
Save one piece of chicken for me for later.
Well, then here, take it.
There's 2 pieces in there. I don't want it now. Look what I have for me.
Okay.
Okay. So, sorry. A little windy outside. It's a beautiful day outside. I wish I could be out there. If I could do this outside in the pretty weather, I would, but I can't. Okay. So let's get back to this fabulous document. We're about a little more than halfway through. Now, this is once again the response from the SJC, I think. The petitioner maintains that the trial judge abused. Oh, I'm glad we stopped. Okay. The petitioner maintains that the trial judge abused her discretion by failing to consider alternatives to a mistrial to afford the defense counsel the opportunity to be heard concerning the declaration of mistrial. Well, they're saying they had that right, that should have been done. That they had a right to be heard. And what the the SJC is saying, nope, you didn't. It's not about you. To begin with, anything that starts with to begin with is never anything good. The court in the Ricino, whatever, expressly reject the proposed proposition that a judge's exercise of sound discretion hinges on whether the judge is one. Oh, I gotta highlight this because this is going to be good. To begin with, one, heard the opposition parties' counsels about the propriety of the mistrial. 2, consider the alternatives to a mistrial. And 3, deliberately instead of abruptly. Ooh, that's going to be an issue. The court cautioned that Washington now here establishes these 3 factors as a constitutional test to determine whether the judge has exercised the sound discretion in declaring a mistrial. Nor could such factors probably be understood as merely illumination of Washington. The court further noted that although the trial judge in this case could have asked the foreperson, I'm going to highlight that. The judge for the could have also asked the foreperson additional follow-up questions, granted additional time for further deliberation, or consulted with the prosecutor and defense counsel before acting. Any of these steps would have been appropriate under the circumstances, and none of the steps was required under the court's double jeopardy. That's a big ouch. The judge's purported failure to do that which is not required by federal constitution is not a basis for granting for habeas corpus relief. This sucks. I'm a little out of breath. Sorry, I rushed. Even assume federal law, like Massachusetts law, mandates that the judge consider alternatives to a mistrial and afford the counsel the opportunity to be heard, the petitioner still would not be entitled to relief. Under the state law, reviewing court considers whether the judge carefully explored alternatives to a mistrial or whether the counsel was given full opportunity to be heard. Citation omitted. Sorry. As described above and as the SJC found, the judge did consider and pursue such alternatives. After the jury's first note reported deadlock, the judge instructed the jury to continue deliberating. Following the second note reported a deadlock in their even stronger terms, she issued a Tui Rodriguez instruction. It was only when the jury submitted the third report of deadlock at which the point judge was statutory precluded from ordering them to continue deliberations without their consent. Petitioner glossed over alternatives to the judges employed in response to the first and second note. She focused on isolation on the third note and contended that the judge in response to that note should have inquired pursuant to Massachusetts Criminal Penal Code 27 as to the existence of any pretrial verdicts. Let me read this. Although the habeas corpus petition the court's discussion of what the trial judges are obligated to do before declaring a mistrial when a jury is at an impasse and a rejection of multiple factor tests determining whether the judge has exercised discretion of mistrial. Yeah, so they're basically saying that she did everything she was supposed to do, and some tone that I'm hearing in this, and it may be just me, but the tone that I'm gathering in this is more along the facts that they're saying she went above and beyond. But the SJC construing Massachusetts Law Rule 27, ... and the court's prior precedents held that the judge was not required to make additional inquiry into the jury deliberations, including the possibility of a partial verdict, or to poll the jurors to confirm the deadlock. And that had she done so, it would have improperly risked coerced verdict, as there was no federal constitution imperative that the trial judge take these inquiries. Citation, SJC determined the further inquiry was not valuable alternative to a mistrial as a matter of state law dispositive. Okay. Nor did the trial judge fail to provide defense counsel an opportunity to be heard. In addition to soliciting counsel's view after the first and second note, the judge found the counsel had made multiple opportunities to object to the declaration of a mistrial if they in fact wanted to do so at the time. Oh, this is important. The thing is that they were asking for a mistrial. Counsel could have objected or at least have asked to be heard on the matter, whether it was requested to be heard at the moment or some point before any final decision was made on the mistrial. While waiting for the jurors to enter the room, especially since the judge had announced to the counsel the jury remained at an impasse. The defense also could have voiced an objection or asked to be heard during the subsequent discussion with the judge about scheduling and status hearing, or even while the jurors were still at the courthouse waiting in the deliberation room for the judge to speak to them. The judge further found that had counsel objected or raised an issue, she would have heard from counsel. You don't know this woman, do you? You don't know Auntie Bev. Auntie Bev doesn't play so nice, especially in her playground. Her rules. Oh my God. She didn't. The defense, she also made a point to note that the defense was no shrinking violets. They never needed the judge to inquire whether they had objections in order to be heard, and she never refused them an opportunity to be heard in court or at sidebar, making it difficult for the judge to believe that the counsel heard that the jury was at an impasse for a third time mistrial was inevitable, and perhaps at the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. Oh, dang it. I knew there's going to be a lot of stuff that hurts them. Despite several opportunities to do so, defense counsel neither objected nor expressed any dissatisfaction with the declaration of a mistrial. For these reasons, the trial judge found not credible the assertion in the petitioner's motion to dismiss the declaration of the mistrial with sudden and unexpected, or the defense counsel asserted in affidavit support of the motion that he lacked an opportunity to be heard. These findings are credibly determined, which are binding, belie the petitioner claimed that the counsel was not afforded any meaningful opportunity to be heard. D. Alternatively, the petitioner may be retired on counts 1 and 3 because she consented to mistrial. For much of the same reason, the trial judge also concluded that the counsel's lack of objection constituted consent to the mistrial. Having determined that the mistrial was manifestly necessary, the SJC did not need to reach that issue of consent, that it declined to do so. A petitioner does not attempt to develop this memorandum in support of her petition, asserting that this court should find that she did not consent because she did not affirmly do so, and she did not implicitly consent because she had no opportunity to object. What? As detailed above, the counsel had ample opportunity to object, and neither did, nor do they ask to be heard concerning the mistrial declaration. Counsel insisted proceedings to schedule a status conference in preparations for retrial. That is sufficient to permit finding of implied consent, which independently removes any bar of retrying the petitioner, irrespective of whether there was a manifest necessity for mistrial. Stating a case, contrast to United States, blah, 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 blah. E. The petitioner was not acquitted of any charges because no verdicts of acquittal were returned, announced, or affirmed by the jurors in open court. In determining whether double jeopardy clause recognizes an event as an acquittal, the question is whether, given operation of state law, the jury acted on their view of a position failed in the case.
I left you a piece of chicken in the box.
Okay.
In the kitchen. One sip.
Pour half of it. Oh, you can't. That was Coke. That's Dr. Pepper. You can take some. Statement. The SJC instruction on what constitutes a valid jury verdict under the operation of state law is definitive and binding in the habeas action. The fundamental requirements. Okay, this is going to be the fundamental requirements for a jury in issuance of a verdict in a criminal cases are set forth in the Massachusetts R. Crim P. 227A. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. This is what's hurting. And this is what they said they did not have an opportunity to do so. Our case law confirms that criminal verdict is effective only when affirmed by jurors in open court. In other words, the distinction between informal agreement and a verdict and the actual return, receipt, and recording of the verdict in open court is central. Only the latter constitutes a final verdict of the jury and criminal discharge. We have consistently reaffirmed this long-standing distinction through our jurisprudence. But I think it's a fair argument to say that they did not have the opportunity, nor was the jury pulled. And even the jurors said that the jury form was confusing. They were supposed to have 3 separate forms, and they ended up with one form with everything on it, is what the juror understood. And the way it read, they thought they had to have all 3 unanimous decided before they could fill out count 1 and 3 as not guilty. So I understand that. The only verdict which can be received and regarded as a complete valid verdict in a jury upon which a judgment can be rendered is an open court and public verdict given and asserted to an open court unanimous jury of the court. So this is what the SJC is upholding and supporting the judge's decision on this particular part. Here, the jury did not return, announce, and affirm a final verdict of any charge. Their only opened in public unanimous acts was the statement to the judge that they were unable to reach a unanimous verdict or attain census. Sensei, get over here. Thank you. Perfect unanimous act or statement, the judge was unable to reach a unanimous verdict or to attain a consensus, remained at an impasse, and they were starkly divided on whether the evidence was sufficient to establish the element of the charges. Far from the affirmation on open court unanimous agreement on count 1 and 3, the notes clearly reflect a lack of consensus on the charges. Even if the jury was deadlocked pertained specifically to count 2, their note made no such distinction, nor did they indicate any verdict would be returned to the judge in open court as required by law. Okay, that's their basis. As such, the trial judge in SJC currently ruled that the petitioner was not acquitted of any charges. The requirement of an open and public verdict announced and affirmed in the court is far from mere formality, though the petitioner argues otherwise. Public affirmation in open court provides safeguards against mistakes. Well, a lot of people believe there was mistakes made here. Verdict must be affirmed in open court, unanimous act on the jury and presence of the whole panel so that each juror may express dissent if their decision has been mistaken, misrepresented, coerced by other jurors, quotation admitted. It also protects each juror's right to re-evaluate their position and to change their mind on any issue or their vote on any charge during deliberation. In section C, read section 495, Mass at 329. The principles recognize that the particular matter jurors may agree in the course of deliberations to tentative compromise on a fact or the case or on the disposition of a related charge as they attempt to reach unanimous agreements. And since the jury should not be precluded from reconsidering a previous vote in any issue, tentative or conditional agreement reached amid deliberations cannot have the force of a final verdict, quotation and citation admitted. Indeed, under the state law, even as the jurors agreed upon a verdict, fill out a verdict slip and walk into the courtroom. Any juror still remains free to change their mind before the verdict is affirmed and recorded. Requiring a jury to publicly affirm their verdict upon the court thus serves as a vital purpose to ensure that the verdict agreed upon in private truly reflects the unanimous, deliberate judgment of each juror under public scrutiny rather than a tentative compromise. So basically, they're saying here is that it doesn't matter what's said in the jury room and what they believe they've reached a unanimous decision on. If it was not written down on paper, read, and recorded in public court, it is not a verdict. It's an agreement. Federal proceedings do not command a different result here, as Bluford makes it clear. There, the floor person disclosed to the judge that the jury had voted unanimously against guilt on 2 of the offenses, were deadlocked on a third, and had not yet voted on a fourth. The jury continued to deliberate, later reported to the judge they had not reached a verdict, and the judge declared mistrial. The defendants in that case similarly argued acquittal is a matter of substance, not form, and that he had been actually acquitted of 2 offenses based on the floor person's early report and jury's unanimous vote. The Supreme Court exposed no endorsement of his premise of substance not formed and instead rejected the argument on its own terms. Wow. I don't see much hope for Miss Karen Reed. Lack of the finality necessary to amount to an acquittal on those offenses, quite apart from any requirement that formed verdict be returned or judgment entered. In italicized and underlined. The floor person's report was not final resolution of anything. The court held because the jurors continued to deliberate after the report, therefore free to revisit their prior votes and change their minds. The court further noted that it would be unjustified to assume that report vote did not later charge, given the possibility that even a single juror could have rethought their position on those offenses. Y'all, down. Down. Go. Go. Come on. You're driving me crazy. Go. Go. Hard to do this when you have a dog licking you. Is she in your place? You go place. Well, if your bone's there, move it. They, therefore, do not foreclose the possibility that the supposed unanimity perceived by some jurors was based on preliminary discussion or straw poll conducted early on in or at the start of the deliberations. Scenario cited by the Supreme Court as a cautionary example, ... For another thing, the purported statement also does not and cannot establish that none of the 12 jurors have changed their mind had the jury gone through the process of returning and affirming a verdict upon the court and that attend such occasion. It is the rendering of a verdict that communicates the true finality and unanimity of the deliberations. Basically, if it's not read out loud and recorded, it didn't happen. Plain, simple. Go. Sensei. I love her, but I get a little claustrophobic sometimes with the go place. Place. Sometimes she just right on me. I have to tell her to go to her place. So, F, how much more do we have of this? Oh, we're almost there. The petitioner requested a post-trial inquiry would require divide the delving into the jury's deliberation and impermissible subject. The petitioner contends, in the alternative, that she could have entitled to a post-trial inquiry of the jurors. The SJC rightly reject that condition, concluding that the requested inquiry would have contravene, whatever. It would go against the Massachusetts law and its prohibition on probing the content of a juror deliberation. The court emphasized that maintaining the secrecy of those deliberations is a bedrock of our judicial system, not only prevent jurors from tampering, but also upholding the finality of oh, come on. It's one of those days, y'all. So, privately agreeing on the verdict they never returned would undermine the fundamental principles. The federal law is not to the contrary, does not compel such inquiry to be made, notwithstanding the state law. During the inquiry into validity of verdict, a juror may not testify about any statement made or incident that occurred during the jury's deliberation, the effect of anything on the juror or another juror's vote, or the juror's mental process concerning the verdict. And the court may not receive a juror's affidavit or evidence of a juror's statement on the matters. I'm thinking. The Supreme Court has repeatedly affirmed that the common law anti-impeachment principle, which is embedded in the federal rule, blah, blah, blah. As a note, is it provides that the jurors may not be asked to impeach or a verdict by testifying about matters internal of their deliberation. The juror may not testify to remarks made by another juror during the deliberation, which shows that the juror at issue lied during the voir dire. Long story short, they cannot ask them any questions about what was said, done in the jury deliberation room. An anti-impeachment rule barred juror testimony as a consumption of drugs, alcohol, or a member of the jury during trial. I mean, there's some things they can, but not this. The request inquiry would necessarily entail delving into the jury's subjective reasoning and deliberative content. Although the trial judge accepted the purported juror statement, which contains 2 or 3 or even 4 levels of hearsay, as a true and accurate purpose of deciding the motion to dismiss, as did the SJC for the purpose of the appeal, the judge explicitly disagreed with the petitioner's characterization of those statements being strong and uncontracted. The judge found that the statements directly contracted the jury's notes during their deliberations, including the final note expressing their stark divide as to the element of the charge. The SJC also find that the statements were inconsistent with and contradicted their prior notes. Well, but here's the thing. If you break it down, when those jurors were sitting in that room, if they truly were confused about the jury form, and it said that you were to fill out this form when you have reached a point of being unanimous about all of it, and they were supposed to have 3 pages, count 1, count 2, count 3, Instead, they got it all on one page. And I do remember there being a little bit of an argument about that. And it was objected to by the defense. There was some confusion on the jury instructions and concerns that Miss Auntie Bev just wiped under the table. So I see on the outside of all this how that confusion happened and why, excuse me, those notes were written in the way they were written. The petitioner argues, as she did in the state's court, that the jury reference to the charges can readily be understood to mean that the counts 2 and its lesser included offenses. And that's true. That is not the more natural and straightforward reading. It is not what the trial judge and the SJC found it to mean. Finding that the entitled difference is here, nor is it consistent with the petitioner's post-trial position at trial. The trial judge noting for the defense to now claim that the notes were subscriptable to different interpretations, such as the court should have inquired further, ring hollow, particularly where the defense counsel had twice argued the jury had engaged in due and thorough deliberations and could not agree. See, that is where this is hurting them right here. And as much as I agree that she was not guilty on count 1 and 3 in that, I believe that they reached it. I believe her lawyers' lack of objection is what's caused most of this. If they would objection was made and it was sustained or not upheld, and the judge ruled against them, at least the objection would have held it for the appellate court. But more importantly, it does not matter what the petitioner now or in hindsight claims in reference of the charges might mean. It matter the jury meant at the time and why they said it. They cannot be determined without inquiring into their thinking and deliberation. Further undetermining the petitioner's assertion as to some of the finality is the inconsistency even among the jurors who are said to have made statements after trials. For example, according to juror C, they were unanimous only on the second degree murder. I'm sorry. They were unanimous only as to the second degree murder. The remaining charges they were hung on. Such statement does not reflect unanimity, okay, to the count 1 and 3. Apparently, even the 5 purported jurors to say nothing of the 7 other jurors were not found of one mind. These and other discrepancies would need to be reconciled to establish any confidence, whether in fact or to what extent any unanimity, I can't say that, unanimity, forget it, have been reached. That will require an impossibility inquiry into the jurors' deliberative process. The petitioner claims that her inquiry is just direct solely to the result of the jury's deliberation and can be accomplished with a single yes or no question proposed to each juror. But the jurors stated agreement in the jury room to find a petitioner not guilty on particular charges may have only been tentative compromise. The juror cannot disclose whether they truly stood, that their agreement merely was tentative, or may have been their final position depending on the resolution of the other charges. The jury further discussion of evidence or some other reason without instructing the heart of the jury deliberation. So basically, they are saying that the jury may have tentatively said first and third not guilty, but if they were arguing over the second and it didn't go the way they wanted, a juror could have changed their mind and it would no longer be unanimous. Sorry, y'all. Additional consideration and against the requested inquiry. Jurors questioned at this point more than 7 months after they were discharged may feel pressure to provide responses they believe will minimize the risk of being harmed or harassed. I have a problem with this harassment thing because they brought up Turtle Boy without saying his name at the beginning of this document. And I have to be honest, Turtle Boy's not harassing any jurors. Noting the inquiry of the jurors is now would occur well after becoming susceptible to outside influences. Now, that I don't disagree with. I think that it could affect them now. They could have said they could change it. Definitely. Didn't mean to do that. Sorry, guys. I meant to do this. A lot of reading, y'all, for a dyslexic person. People associated with this case have been charged criminally with witness intimidation. Oh, you mean Turtle Boy? Individuals. How many individuals? It's only one individual. Have also expressed outrage at the jurors. Okay, individuals have. This is true. At the outrage at the juror and sought to identify them to release their personal information. One of the jurors has said they feared for their personal safety and for that and their family. They worry that they will be subjected to harassment or even physical harm because what they did or did not do in the jury and the outcome of the deliberation. Several of the purported jurors who remain anonymous. In the view of the circumstances, a yes or no question may not capture the jurors' nuanced views and concerns or lead to a reliable, accurate understanding. Allowing such inquiry raises forward-looking concerns that will. The proper evidence of the decision of the jury is a verdict returned by them upon oath and affirmation in open court. It is essential to the freedom and independence of their deliberation and their discussion in the jury room to be kept secret and inviolable, and admit the testimony of the jurors that would took place there would create distrust, embarrassment, and uncertainty. Submitted. I'm going to take a break from reading, y'all. My brain hurts. My brain hurts. That is just insane. We are not going to go through 147 pages tonight. If I feel up to it, we'll come on and read a lot of that. Let's see, this is 39, that's 29. So we have a Commonwealth of Massachusetts Supreme Judicial Court, Commonwealth Appellee, Karen Reed Appellant, Commonwealth Supplemental Recovery Appendix. What this is basically, just so you know, I will show it to you. Let me get it centered and everything. This here is this document here. The juror's name has been removed. That looks like a female's handwriting there. Here it is again. This the second note that was submitted. And here is the third that was submitted. That's all that's in that document. And this document here is 29 pages. So we'll wait. Isn't that what I just read? Yep, we're not going to do that. So basically, we're somewhat caught up, not 100%, but a good portion of it. And they should be starting shortly. Shortly. How's everybody doing? Don't forget, you got to hit the like button. I don't know how many likes I have. Let me refresh my page. 21 likes. Woohoo! We doing good, y'all. We doing real good. Thank you very much. Y'all keep it going. Come on now. Because today and tomorrow are the last days before we do the drawing. Oh. So, that wore me out. That's a lot of brain power for a dyslexic person to do. I am. Did y'all hear about what is his name? I got his face. Let me get to it. That actor and his wife that were found deceased in their home. Why can't I find him? It was all over this morning. I can't find it now. An actor and his wife were found deceased in their home together. He was 95, I believe. Why can't I find it? Hello, it's Britt. How are you doing? Gene Hackman. Thank you. Gene Hackman. I loved him. He was so great. I wonder what caused. I hope it may have been carbon monoxide. He and his wife were found unalive. She's a beautiful Chinese woman. Were found unalive in their home. Gene Hackman. I hate all these damn commercials. Gene Hackman's wife, Deb, deemed suspicious with scattered pills found, but no signs of gas leak. The actor's wife, Betsy Arqua, was found in the couple's bathroom near the pills, a space heater, and their dead dog. What? The dog, too? The French Connection star was found unalived in his Santa Fe, New Mexico home with his wife, classical pianist, and their dog on Wednesday. Though the Santa Fe police confirmed the Entertainment Weekly they did not suspect foul play, authorities later said they have not ruled out foul play. In a press conference Thursday, reported local outside media. Oh my gosh. Hackman's daughter, Elizabeth, told TMZ that her family suspected carbon monoxide poisoning. However, the affidavit for search warrant from Santa Fe detectives reviewed stated that the circumstances of the deaths were suspicious, but with no obvious signs of gas leak. Autopsy will reveal a lot of that. A lot of that. The affidavit stated that the wife was found in the bathroom floor next to scattered prescription pills and space heater. The respondent officer thought could have fallen if abruptly fell to the ground. Her body was already decomposing. Mummification of both hands and feet? That's weird. The German Shepherd, 10 to 15 feet away from her. The two other dogs discovered alive on the property. They found Hackman in the home's mudroom, where he appeared to have suddenly fallen, with a pair of sunglasses and walking cane nearby. They found Hackman and Arakawa, I can't say it, in the similar state. Nothing else was reported out of place. So, oh, that's so horrible, y'all. That's horrible. Y'all, we only have 7 likes in the competition, and we have over 21 thumbs up. If you hit the thumbs up, please hit the like. Okay, Miss Haley. Go get that TV time. But yeah, that is such a shame. So they were supposed to be back at 1:30 their time, right? They're not. I'm sorry, y'all. I'm just eating some mashed potatoes. Ugh. So with that, um, I don't know what that is. I need to delete some of my stuff. That's what I'm looking for. Mm. Here we go. Y'all need to put that in the comments for the competition or for the drawing. I need to do this. I haven't done this in a while. I want to welcome Ollie T to our family. They are our new sponsor. Ollie T is a veteran, woman-owned company. They are passionate about creating artisan small batch herbal teas, focusing on self-care and wellness, while at the same time offering tasty drink options. Ollie Tea does not incorporate scenting or flavoring agent and is naturally caffeine-free with no added sugars. They let the natural ingredients speak for themselves. The herbal teas are packed as loose leaf and in convenient tea bags. Certified Go Texas and homegrown by heroes. They offer many different choices from lavender citrus to lemony mint to restore and to scarlet nibs. They also offer fabulous Christmas gifts such as these wonderful tea strainers. Y'all, this is absolutely beautiful. Please click on the QR code or go to www.buyollytea.com to get your tea. Let me know which is your favorite. I hope you enjoy. Y'all, that is some really good tea. And y'all need to go over there and start getting some. It's even good cold. I drink some of them cold. Make it like a regular flavored iced tea. It is really good, y'all. It good, 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 good. I thought I saw a camera wiggle, but I could have sworn that they said be back at 1:30 their time. That's 3:30 our time. They're 30 minutes past due. Come on now. Yeah, there's some wiggling. I think they're gonna be here in a minute. Oh, I'm ready for a nap. Yesterday is catching up with me, y'all. I gotta be honest. It is catching up. By the way, I just have to thank you. Thank you so much for your support. Somebody asked if I had the BS meter. There it is. There's the BS meter. By the way, our hearts and prayers are with the Pope Francis and all the Catholics out there in the world. We're praying for recovery for him. He is still struggling. He is still struggling. And that is not a fun place to be. I'm trying to double check the news. Ooh, excuse me. Thank you guys for sticking with me. It's a long day today. 3 rescued after a boat capsized near Captiva, Florida. Oh my gosh, email notification. Let me go check that. Oh, no softball. We don't do softball. Yay! She returned. Oh my god, they're gonna have interpreters for the show? Oh, they've already hired them. Dang it. Well, I guess I'll be going to the concert and enjoying it myself. So, yes, one of the things that's very difficult for a lot of deaf people going to these concerts is having interpreters. But the problem is when they hire interpreters from agencies, they don't have the most of them. You really have to know what to ask for. Um, because when you have people interpreting concerts versus people who interpret lectures, big difference, y'all. Big difference. It don't work so well. Mm. I hate it when you get something in the mail that says, "Oh, you received credit," and you pull it up, it's a 5-cent coupon. It's like, "Seriously, people? Seriously, people?" I'm like, "Nah, that don't fly." Mm, thank you. Sorry, I'm trying to get caught up on some things. So, um, we are oh, let's do a recap of this trial. A lot of people don't know. Uh, the thing that drives me nuts about this woman, she's in her 40s. Number 1, I don't think it's good for any woman to be sending pictures of themselves anywhere to anyone in this day. I mean, it's bad enough back in the day where they'd take pictures and they'd have negatives and they can print them over and over again. But that took work, and you had to be able to find a lab that was willing to, um, produce those pictures because some of them are illegal. Nowadays, you take pictures of yourself and you can send them anywhere in about 10 seconds. Hundreds of people can have it. So, what is she teaching her daughters? I don't. What is your opinion on it, y'all who are listening and watching?
Messages
On
between
her
the
the
defendant
JJ
and
pictures.
her daughters in People's 219 with respect to the date of April 21st of 2017. When you, it's been previously marked, People's 194, there's a 26 in the lower left corner. When you went through the property in this case, was one of the items, this receipt that has the same date at 6:05 at night for a store on Melrose.
Yes.
If we haven't already, we object this to keep it.
You have, and it's still horrible.
She almost laughed at that. She's been on the stand part of yesterday, all of today.
And showing you what was previously marked as People's 96, I asked you about going through the defendant's emails. Did you also do that and find documentation that we see here in People's 96, page 24, and the accompanying documents regarding Fabio Sementilli's benefits that was sent May 17th of 2016,
Yes,
as well as what we see here in People's 97 from August 4th of 2016, again, regarding Fabio Sementilli's benefits through Cody.
yes.
I have a set of text messages that are dated beginning February 8th of 2017. 6 pages in length. May they be marked as People's Exhibit 220?
Yes.
Starting at the top, People's Exhibit 220. Did you review with respect to the defendant's Celebrite report from her cell phone, as well as email, as we discussed, messages that took place on February 8th of 2017 and dates thereafter relating to her communications with her daughters?
Yes.
And in this set of messages, can you describe for us what we see here on February 8th, a couple of weeks after the murder of Fabio Sementilli? There we go, at 9:30 at night.
Objection, Your Honor, this was already testified to, and it's cumulative. It's relevant,
I don't-
and it's argumentative. It's letting the prosecutor make their.
I'm sorry,
Can
counsel.
we approach, Your Honor?
Let me just rule, and then I'm not going to approach. One, I've warned you before about speaking objections. This is the last one.
You should.
Next, your objection's overruled. This has not gotten it before. Proceed.
Can you tell us what we're looking at here?
This is a instant message exchange between Bella and Monica. The first message, Bella saying, "Come home, all my friends are leaving."
And this is a message that is sent out from Bella to her mother at 5 minutes to 10 at night, correct?
Correct.
California time.
Yes.
And then is there a response from her sister, Jessica?
Yes. I'm sorry, I misspoke. It is like a group text between the 3 family members. And Jessica says, "Okay, on my way home." On my way.
And subsequent to that, about 50 minutes later, is there another text from Bella on this text message string
Yes,
asking if Jessica is almost home?
correct.
On the second page, do we see a response from Jessica at 10:27?
Yes.
And then what do we see here at 10:27 p.m. on February 8th, coming from Isabella?
Message to both Monica and Jessica saying, "Guys, what the hell? Why leaving me alone for so long? I don't want to be alone in this house."
And then is there another message from her about 11 minutes later at 10:38 p.m.?
Yes.
And is that what we see here? Don't forget I exist or anything, I'm not opening the door.
Yes.
And then at 10:43 and 54 seconds, what do we see here in green?
That's a Monica responding, Jess, where are you? Get home.
And then do we have a response from Jessica that comes in at 10:44 and 29 seconds?
Correct. I'm getting off the freeway with RN right now.
Moving on to the date of March 9th of 2017. Once again, can you tell us what we see here at 10:12 p.m.?
This again is a message from Bella in the group thread, asking if one of them can please come home.
One of them being her mother and Jessica?
Yes. I believe she was babysitting. Giuliani is falling asleep and I'm studying, and basically she didn't want to be alone.
And she says, basically, I don't get why you guys leave me alone all the time.
Right.
And then there's a response from Jessica.
Yes.
And at 10:13 p.m., does Jessica send a message back to her sister and mother?
She does.
And what does she say here?
I'm always home alone. Just lock the doors and put the lights on.
And then is there another message from Jessica to her mother and sister at 10:14 p.m. and 15 seconds?
It's from Bella.
Sorry, thank you.
Yes, says still, I don't care. Then you wonder why I don't talk to you guys, because you're never home. Just leave me here to fend for myself. Well, I'm not you, Jess. I don't like being in this house. It's worse when I'm alone.
I couldn't imagine her living in that house after the death of her husband, especially when she knows her daughter is
And
so
on the
uncomfortable.
next page,
There's no choice but to live there.
at the top,
Child.
is
That's
there a
horrible.
message from the defendant back to her daughters?
Yes,
And this is at 10:16 and 32 seconds.
correct.
And what does she indicate here? What's the response?
WTF, which I know means
What
what the
the fuck?
fuck is going on.
And subsequently at 10:17, is there another
I'm
message?
gonna object, Your Honor, there was a message that was.
That's correct. You can go back.
That's okay. Council Cover, please let them call.
Go back, please.
All right.
Let's
This is
move along.
from Jessica at 10:17 p.m.
Yes,
And then is there another message from the defendant?
yes.
What is that?
I'm at a comedy club and this is what I gotta see! Exclamation mark.
She
And
doesn't
then
take
are
out
there
her
two
one bit.
messages from Jessica back to her sister regarding their mother?
Well, I believe that the first one is actually to Monica, Mom, don't worry, and then follow up to her sister, let Mom have fun, I'll be home at 11.
On the next page, does the defendant respond?
Yes. It's 10:17.
Please work it out.
Correct.
And then is there a message back from Jessica?
Yes.
I'm
From
sorry, from
Bella.
Bella.
Yes.
And what does she say here at 10:18 p.m.?
I'm making that therapy appointment tomorrow. It's like you guys don't even care. Good night.
And the defendant, does she then respond at 10:19?
Yes. What? With 5 question marks.
And then is there a message from Jessica to her sister and mother?
Yes. Isabella, stop overreacting. You're ridiculous. You're never home. We have lives too.
And on the final page, is there a message from Jessica with maybe a correction?
Yeah, I believe she's correcting the bruh to your being ridiculous.
And then is there a message back from the defendant on March 9th, 2017 at 10:20 p.m.?
Yes, she writes, "I'm so very hurt and disappointed. I'm coming home."
And then is there a message back to her mother from Isabella?
Yes, she says, "No, it's fine."
Do you know what MIM means?
I do not.
Did you also review messages when we talked about the cell phone extraction for item 119, the defendant's iPhone, that came from
Woman, get your crap together.
Robert Baker on December 17th of 2016?
Yes.
Transcripts that we're going to ask to pass out to play a couple of voice messages. I have a audio file for a voice message on December 17th of 2016 from Robert Baker regarding Viber. We'd like to add it to the flash drive, which is ready to mark as People's 158.
Very well. You can do it too.
I'm sorry?
Do it too.
And the transcript, may that be marked, please, as People's 221. And if I may pass out the transcripts.
Yes.
It's only a
Thing
few.
I mentioned, that applies, all transcripts applies to this as well.
Sorry about that. Waiting on. What's that smile for? Yeah, I want to see what that smile was for.
Creative contest.
So that was a phone call from Robert Baker to the defendant that was on her, as you said, her iPhone 7, correct?
Correct.
And that was on December 17th of 2016 that mentioned using Viber, correct?
Correct.
And on the phone, did it indicate the defendant's phone that it came from the phone number, again, that would come up in the contacts the defendant put into her phone for Louisa or Arbol for 213-272-1093?
Yes.
Your Honor, I have a second very short voicemail from Al Birdsong to the defendant on May 17th of 2017, which is also contained on the flash drive marked 158. If the transcript could please be marked as People's 222, is it?
Yes.
And I would like to pass out the transcripts.
I'm gonna object this. Obviously,
May I?
you gotta object this seriously.
That's it, please.
Sure. And I'm not offering it for the truth.
One moment, please.
So ruled.
May I pass out the transcript?
Yes.
Oh, you were so slow, woman. And I can't zoom anymore because we're caught up. Yeah, we're caught up. Uh, so, what are we fighting over? Oh, come on, for the love of the Lord.
Other people, thank you.
Do you know who Al Birdsong is?
Yes.
And where does Al Birdsong, back in 2017, where did he live?
In Nevada.
Just say.
Did you have any conversations with Mr. Birdsong or review transcripts and audios with respect to his interviews in this case,
I,
as well as, research Mr. Birdsong as a potential suspect involved in this murder?
yes, I never had any direct conversations with him, but I've read and listened to all of the transcripts and interviews and done extensive investigation on Mr. Johnson.
Were you also here yesterday when Mr. Roger Brown testified that he knows Al Birdsong by the name Bird and that Mr. Birdsong lives in Las Vegas?
Correct.
Is that consistent with your knowledge?
Yes, it is.
Objection, no foundation.
Oh, well,
When you reviewed the defendant's extraction from her cell phone, did you also note that there were 2 different voicemails from Gail Burlingame consistent with what she testified to when you were here the other day, yesterday?
Yes.
I'm gonna check if consistent with that argument.
Consistent with
it's
leaving,
overruled.
consistent with leaving messages for the defendant regarding the purchase of a Mustang.
Yes.
I wish I could play the do 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 do. I really do. Wow. Just wow.
Also, obtain information, including audio files for jail visits that were made to the defendant.
Yes.
How does one go about obtaining video or audio files for jail visits to inmates when they are in custody of the LA County Sheriff's Department?
Well, initially you have to make sure that the person that you want to recover that visit, that video or audio of that visit, that they're placed in the correct visiting cells that has the capability that has a camera or a listening device or whatever. And once you set that up, then it's just they have a visit, it's videoed, and then you sort of request a copy of that video.
Okay. And does this apply to all of the sheriff's jails throughout the county of Los Angeles?
Yeah, I believe so.
And in this particular case, did you obtain jail visits relating to the defendant throughout her time in custody?
Yes, there were many that had already been obtained by the original detectives, and then I've reviewed all of them, and then we did obtain some additional.
While we're on the subject, can you also, as a detective assigned to a particular case, obtain jail calls made by inmates to people outside of the jail? Let's say if they wanted to call home or something of that nature.
Yes.
How does that work?
So in that case, it's a little different in that an inmate is given sort of a individual number, PIN number for lack of a better word, that is their number. And when they get phone privileges, all calls within the LA County jail system are recorded. There is a message that makes it very clear that they're recorded. And so then the process after that is merely just reaching out to the coordinator that manages that system and requesting all of the recordings. And when you request it, you just need the inmate's name and the inmate's number.
And in this particular case, did you make requests for jail calls relating to the defendant?
I did.
And do you make those requests through unique or individual booking numbers?
Yes.
Would it be fair to say that you obtained hundreds,
I would venture to say thousands.
thousands of jail calls that the defendant made?
Yes.
Would it also be fair to say that you obtained hundreds of jail calls that were made by Robert Baker?
So yes, when I guess when I said thousands, I was kind of doing it as a batch in the case, that there was thousands as far as the case made by the both of them. But yeah, hundreds, if not thousands, by both of them.
Now, in terms of jail calls, you mentioned the fact that inmates have individual PIN or personal identification numbers. If you wanted to request jail calls made by a particular defendant on a case that you are working, would you only then be provided with the calls that are logged to or associated with that particular inmate's PIN number?
Yes.
Are you familiar with, in this case, attempts that were made, sometimes successful, sometimes not, by the defendant along with Robert Baker to get around that process of having their jail calls identified and thus recorded under their own PIN numbers?
So
Yes, that happened multiple times throughout this case.
Can you explain to us what happened, what they did?
There was a few different tactics that were made. The most common, I think, throughout the jail system is just to use somebody else's PIN number. So you get your cellmate, or they sort of seem to trade numbers. And if you were to make a call and log in somebody else's PIN number, then those calls are going to be on that inmate's recorded calls. And if I didn't have that inmate's number, then I would never get those calls.
In other words, if you weren't able to identify who that was an inmate within the men's jail or the women's jail, you would not be able to obtain those calls for the defendant if they used other inmates' PINs.
Correct.
What steps or what investigation did you do in order to try and identify which other inmates' PIN numbers the defendant and Robert Baker used in order to try to conceal their calls?
A lot of times, if you let the actual deputies within the sheriff's system know that this is happening, they can help you try to identify other names associated and other PIN numbers. In this case, the only way I could really try to keep up was to continuously monitor the calls, listened to the calls, and within those calls, they were, when they were successful in talking to each other, they would talk about either within the calls or within letters and other communications, ways to try to be able to have a code or a pen pal or something in order to go communicate undetected by law enforcement.
That's the conclusion, Your Honor, no foundation.
Overruled.
What type of codes are you referring to?
We recovered these coded, they talked about Robert and Monica talked about them both in the mail that they were sending to each other and on the calls where they were able to talk to each other, and they would identify a name or a date or something that they both would know the answer to. So it was like our friend's favorite dog, or at one point it was the day we met or the day we had our first date. Well, I don't know what that is. Once you have that date, then they assigned like a letter to every number and would do this whole intricate, they would say 1 minus 3 and 2 plus 7. And if you knew the starting letter, then you could kind of figure it out. But it was, and then it would change. They would change that starting letter or word phrase, and then we would have to try and decipher that as well.
Would it be fair to say that although you tried to identify the other inmates whose pins they were using to be able to communicate from the male jail facility to the female jail facility where the defendant and Robert Baker were being housed, that there was no way to be able to obtain all of those calls?
Objection, no foundation, cause for speculation.
That's wrong, that'd be sustained.
Would it be fair to say that without knowing exactly whose PIN numbers they were using in order to communicate secretly, there would be no way to identify all of the calls that they made to one another?
Objection, also seems fact.
As formed, that'd be overruled. There's been testimony as to this.
Is that true?
That's true.
So even though you were able, as you said, to identify and obtain thousands of jail calls, you were unsuccessful because of their efforts to evade law enforcement, listening to their communications, to identify and obtain their communications.
Objection, argumentative.
Sustained.
Were you able to identify and obtain all of their jail communications?
Objection, speculation.
Sustained.
When you said that they would often change the PIN numbers that they were using, was that because through some of the jail mail that you were able to obtain, as well as some of these jail calls, they discussed that certain inmates' pins who they were using would no longer be good because those inmates at some point were released or moved to other facilities?
Objection, that's legal.
Overruled.
Yes, for one reason or another. I know sometimes it was they were released, they moved to other facilities, or there was occasions I recall where they no longer wanted to sort of participate. They were no longer comfortable participating in
Motion is correct, that's speculation.
Not as formed. It's overruled.
And did they, in jail mail that you were able to obtain and jail calls that you were able to obtain, continually discuss that exact issue, that they were constantly needing to find a new inmate?
Objection, that's leading an argument.
So roll.
Yes, they did. There was also some calls that we intercepted where I overheard the actual inmate of the pin they were using typically has to announce themselves at the beginning of the call. And there was a call or two where they actually voiced that they weren't comfortable, or the other person on the line that they were talking to was not comfortable with what was going on.
Okay. And
Some foundation is to any date, time, when this was occurred.
Overruled.
did the defendant, along with Robert Baker, also refer to these other inmates by a particular phrase or name?
Yes, there was some that had actual names. Antoinette comes up as a name I remember. I think Tim on the male side, and then in general they refer to him as PPs, which is like a pen pal, but it was just PP.
And at some point in time during these recordings, did one of the two of them at times slip and actually use the words pen pals, and then one or the other would correct the other and say use PP?
Yes.
Objection, Your Honor. Calls for speculation, it's leading.
Overruled.
And in terms of being able to identify certain communications, did you also request through court orders to be able
I'm gonna
to?
object to reference to court order. That's argument is it not necessarily precede the question.
Again, Your Honor,
No.
can we approach?
Not yet. It's overruled.
With respect to the jail mail, did you obtain court orders in order to have the sheriff's department copy mail that was found in the defendant's and Robert Baker's cells at certain times, and then put the mail back once they were copied?
Yes, there was both. We have some mail that was recovered and booked into our evidence, and the majority were recovered and then copied and placed back into the cells.
And what was the point of having the sheriff's department copy mail, provide you the copies, and put the originals back into the cells?
It was very important that we at least try to not let Robert Baker and Monica Sementilli know that we were looking at their mail. They were obviously corresponding back and forth to each other, and we're coming up with these alternate ways to do that. And we were, again, just trying to stay ahead of them and keep up with the ever-changing pen pals and things like that.
All right. Now, is there also a policy in the sheriff's department where they try to prevent inmates from communicating with their co-defendants on cases that are housed in other jails,
Yes,
such as in this case?
yes.
And is there also a policy by the sheriff's department that if they are communicating with their attorneys or to someone that they identify as an attorney, that oftentimes those calls will not be monitored because they're privileged.
Calls for speculation.
I'll allow this.
Yes, and as law enforcement, if we're listening to a call and we identify that it is an attorney, we immediately stop that call, notify the prosecutor, and of course don't use that call for listen any further.
You heard Roger Brown talk yesterday when he was testifying about a mutual friend that he shared with Robert Baker by the name of Howard Lynch. Did you do any investigation on an individual that is an attorney by the name of Howard Lynch?
Speculation as to confession.
Overruled.
Yes, I did.
And Howard Lynch is he an attorney who, as we heard from Mr. Brown yesterday, was or is a close friend of Robert Baker?
Yes,
And did you identify that Howard Lynch was utilized by Robert Baker and the defendant in order to communicate directly to one another?
Objection, speculation, hearsay, and observation.
Sustained on the first ground.
Did you listen to phone calls that were placed to Howard Lynch's office?
I did.
This was his law office, is that right?
That is correct.
And can you tell us about this plan that was put into place by the defendant and Robert Baker utilizing Howard Lynch's law office?
Objections, calls for speculation.
Sustained.
Did you listen to calls where they discussed putting a plan into place?
I did.
And were those calls actually recorded?
They were.
And did you obtain some of those calls?
I did.
Did you listen?
Attorney-client privilege.
One, you do not have standing as to that. Two, there is no privilege as to this. It's overruled.
Did you listen to the calls that you were able to obtain?
I did.
And what, if anything, again, did you learn from listening to these recorded calls through Howard Lynch's law office?
As I recall, initially it started out where they would call in at different times, but they had a prearranged sort of time that they tried to call in on certain days. And
Sustained.
Is that contained in the recordings?
it is.
May I proceed?
And for instance, when Monica called, she would leave a message for Robert, and then Robert would call into the office. That message would be relayed, and he would leave a message, and this went back and forth through Howard's associates at the office. As it progressed, they came up with a system where they were actually able to somehow call in at the exact same time and link the calls together. Of course, I don't know if they were putting the phones together or whatever, but in the recorded calls, they're having conversations to each other through what we call a three-way call.
Now, just like you testified to with respect to the scheme that was utilized to use other inmates' PIN numbers, did they also come up with a term? You told us with respect to the mail, it was PPs for pen pals. Did they also come up with a term that they would discuss for when they were able to use other inmates' PINs to communicate directly to one another through some third party, such as Mr. Lynch.
Speculation, no foundation.
Overruled.
I'm not sure I'm understanding your question. I know they used names, different names that they would identify each other by other than their name.
Did the defendant in some of these calls tell Mr. Baker that she didn't want to make phone calls unless they were clean calls?
Yes.
What are clean calls in terms of what she, the defendant, and Mr. Baker discussed?
I'm gonna check calls for speculation.
Overruled.
They were trying to find a PIN number, an inmate number that they could use that wasn't compromised. And the problem that they were having is that as soon as they couldn't, of course, tell each other the PIN number over the phone, because then we would have it. And Baker kept using his own PIN, and Monica was adamant that they shouldn't talk that way, that it would be recorded, we would find it, and that they needed a clean number, which meant a clean PIN that we didn't know that number.
Your Honor, I actually have one jail call that I would like to play. The audio will be on the flash drive that has been previously marked as People's 158. The transcript, may that be marked, please, as People's, is it 223?
It is.
Jail visit.
To be clear, this is a jail visit and not a jail phone call?
Yes,
Very good.
I believe it's a video.
Yes.
You
Shouldn't provide any discovery, Your Honor.
you may. Edmondson still applies. You do not have a transcript?
That's good. You want to see mine? Sure.
I'm sorry about that. Every single semester, I have to send them the same document over and over and over again, and they're supposed to keep it in my file. But they never find it. You know how things go with government and colleges. So I appreciate y'all's patience. Thank you so very much. Oh, it's just one of those things, you know? You just got to get through it. So they keep giving me that. I just got the same letter 3 times. It's like, what the heck? Okay, let me explain a little bit while we're sitting here with no one doing anything. We're at sidebar. All right. Toxic. The clue of this, the base of this trial. She was married to Fabio. Fabio was a renowned hairdresser. He worked with corporations and company that had products. He became a featured hairstylist at their conventions. They did shows and educationals. He was 6-figure earning employee. They came down from Canada. The company paid, helped them get settled, etc. She met another guy who was a porn star manager, and they got into an affair. She asked him and somebody else to unalive her husband for the $1.6 million life insurance policy. Total benefits would have been well over 2.5 million.
That's good. You want
And
to see mine?
she was all about money, and she has over 240 pictures of every orifice of her body. The vajayjay, the whole naked, everything naked.
I can't see
Everything
it. I
naked.
can't see it at all. What does it say?
She wanted to be a porn star at in her 40s.
You couldn't see it? It says ride or die.
She had a tattoo put on her in prison. Yeah. She one complicated, crazy woman. And she lied a lot, but she kept going to the police, and the company he worked for paid
And more on the transcript goes
about
further than.
$80,000
There's an entire conversation that
for his
I
funeral,
understand that. The last 2 sentences need to be.
I'll ask.
multiple memorials,
After
to have
that
his body
portion,
transported
does
to
the
Canada.
defendant tell her
I
daughter
mean, they did a
that
lot.
the tattoo is just ink, it's just pen?
And
Yes, I'm
Sorry.
kidding, it's just a pen, I wanted to joke.
they gave her 6 months of his salary plus health benefits after he was murdered. They even had things written into their corporate policy and procedures in order to do that. She got close to $3 million total. Well, not physical, she didn't get it. From the company alone, she got probably close to $400,000 in benefits, pay, insurance, all of that stuff. She then was going to everybody, telling everybody she was poor. But what she was doing after he had died with the boyfriend was going to Las Vegas, having girls' weekends. I mean, she's crazy. I hope that helped.
Look around with you.
Okay. The term ride or die, did that term come up multiple times in various forms of evidence that was recovered from the jail?
Yes,
No foundation.
So real.
Did it come up in jail mail that the defendant sent to her lover, Robert Baker?
multiple times.
Did it come up in conversations that they had that were recorded?
Yes,
Now, in the course of your investigation, did you also write
The Instagram lifestyle, you know,
Yeah, there's
great on
fabulous life.
Instagram, but
Yeah.
when
different types of information that you tried to gather, just as we heard about this morning with respect to the burner phones?
I did.
With respect to one of those search warrants, was that written for, and did you obtain a authorization to obtain what's referred to as a DNA reference sample?
Yes, I did.
What is a DNA reference sample?
Basically just a swab of an individual's DNA to compare against typically other evidence in a crime.
And what format does that come in terms of how it's obtained where you're concerned as a law enforcement officer?
With the warrant, with a warrant, we obtain the warrant, go to wherever, in this particular case, it was to the LA County Jail Women's Facility. And we typically have 2 swabs and they're in a sealed container. We obviously wear gloves and take those sort of precautions against cross-contamination, and just use the swab to swab the inside cheek, both sides of an individual. You're actually looking for skin cells as opposed to saliva for the DNA. And then we package it up and seal it in an envelope and book it as evidence.
And in this case, did you obtain, pursuant again to a search warrant, a DNA sample or buccal swabs from the defendant at the in the women's portion of the sheriff's jail in LA County?
Yes, my partner and I, Esther Myape at the time, went to the facility, and I believe Esther actually swabbed Monica.
Hello, Miss
In your
Candace.
In my presence, yeah, we were both there together.
And did that take
How are
place,
you,
the
beloved?
service of that warrant on January 27th of
How are you,
2001?
beloved?
It did.
And then did you subsequently, I'm sorry, 2021?
21.
Thank you. Yes?
Yes, 2021.
And did you book those swabs for the defendant's DNA reference sample under item number 201, specific to the DR number, the LAPD unique case number in this case?
I did.
All right. And then did you subsequently direct
Isn't that
evidence
fun?
transfer
Not as bad as they used to be.
Randy Zepeda
Still
in
hate them.
the DNA serology section of the lab?
More the nervousness of the results.
Yes, when we request the lab to look at a DNA sample that's booked, they automatically generate the transfer of the evidence. So the request basically generates that it will be transferred to the lab.
Your Honor, I have a stipulation that I would like to offer at this time. May the documents please be marked as People's Exhibit 224?
Yes.
Thank you. Stipulation, June 14, 2017, search at Queen Victoria. On June 14, 2017, Los Angeles Police Department personnel searched the Sementilli residence at 5012 Queen Victoria Road pursuant to a legally valid search warrant. The following items were collected at that location and identified as indicated below: a gray LG V410 tablet with serial number Z as in zebra, N as in Nancy, F as in Frank, V as in Victor, 410, and SIM card 818-640-8193 through AT&T, registered to defendant Monica Sementilli. The tablet was recovered from a chaise lounge in the northeast corner of the residence's living room by LAPD detectives. The item was assigned PID number 5 as designated as evidence item number 82. A gray HP desktop computer with serial number 8, C as in
That's a good
cat,
thing.
C as in cat, 6500, C as in cat, X as in X-ray, X as in X-ray, utilized by defendant Monica Sementilli. The computer was recovered from a desk in the family room on the residence's second floor by LAPD detectives. The item was assigned PID number 11 and designated as evidence item number 88. 2 reference buccal swabs were collected from Robert Baker by LAPD detectives at the Van Nuys Jail on June 14, 2017, which were booked into Property Division as item number 158 and subsequently transferred to LAPD's Crime Laboratory for processing. Counsel Join?
Joey,
I have no idea what they're talking about right now.
Let me inquire. Esther, do you want me to book evidence envelopes separately as different numbers?
Individual items.
Yeah.
Yeah.
Okay.
Thank you.
Your Honor, I have an evidence.
You want multiple envelopes marked individually?
Each envelope and its contents.
Yeah.
Individual, yeah.
Very well, as far as the contents themselves, those are not individual. The envelope and its contents,
With the envelope and its content.
right.
Yeah. Your Honor, I have a yellow envelope. On the exterior, it has the number 203 to 204 and 206 to 208 attached to a property report. May it and its contents be marked as People's 225.
Yes.
Thank you. Detective, showing you what's been, looks like repackaged and marked now as People's 205. Looking at the exterior, I'm sorry, 225. Looking at the property report attached to the front, do you recognize this property report?
Yes,
And how is it that you recognize it?
I completed it.
And what did you book into evidence in this under the numbers 203 to 204 and 206 to 208?
There was an address book recovered from Robert Baker's cell, miscellaneous papers, basically.
Okay.
And a newspaper clipping.
Okay. And were these items that you recovered from his jail cell with the assistance of sheriff's personnel?
Correct.
Okay. If you could please remove the items from the envelope and describe them individually.
Thank you for putting the gloves on, my dear. It does make it a little bit more helpful in maintaining the integrity of the evidence, which a lot of people seem not to be doing in certain courts. Just saying.
And 204 is basically a county issued sort of phone book where they put important phone numbers, PIN numbers. There's a lot of PIN numbers.
What date did you recover these items from Robert Baker's jail cell?
March 18th, 2021 at 8:30 in the morning.
And which jail was that recovered from?
Los Angeles County Jail. I can't remember at this time whether he was in Twin Towers or the county jail.
All right.
The phone books.
Okay.
They have the
Are those the little
numbers,
black
and
books?
some of them have other inmate PIN numbers.
Okay. And did you identify each of them as individual numbers on your property report?
Item numbers?
Yes,
Yes.
that match up to the numbers I gave you, 203 and 204, 206, 208.
Correct.
So if I were to show you, just for instance, what is 203, within a couple pages inside, we see numbers, looks like phone numbers, extensions, and then perhaps inmate booking number.
Correct.
She looks a little confused.
And if we
She actually looks a lot
move on
confused. Like,
to another page,
what
we
is
see
that?
Ken Rasmussen
Where are
with,
you going
again,
with this?
what appears to be another booking number, or, excuse me, an inmate number.
Yes, that's a booking inmate number.
A Jose Rivera again with an inmate booking number.
Yes.
And 204, the exterior. It looks like something about Bible study, correspondence, courses. If we open this up, once again, does this appear to have various names and numbers?
It's the little.
As well as the address, 331 Salem, for Roger Brown's address in Glendale.
Yes.
What are the other items in there?
206 is miscellaneous paper. It's in this little envelope.
Oh.
It's like a little love note that says, "I love you, baby."
Okay.
Oh, who wrote
Looks
him
like
a
small
love
point
note?
envelope.
Yes.
Is this what you would have used to book this item into?
Yes, I put it in that envelope.
Looks like this, 206 on the outside, and then this is what was inside.
Yes.
Small piece of paper. It looks like it has the writing that you said, "I love you, baby," with a red heart, and maybe some type of a note, correct?
Yes.
Okay. What's the next set of items? Returning that to the point envelope.
207 is a newspaper clipping.
Regarding what?
This is the newspaper booking photo of Monica Sementilli. Do you want the envelope?
Oh, yes. And this, again, a small coin envelope. Is this what you used to book this newspaper clipping photo?
Correct.
207 and the defendant's booking photo.
Yes.
Okay. What's the next item?
It's just we We book these as miscellaneous papers because it's just exactly that. It's different papers with writing, some pictures, some newspaper articles.
Some of these items appear to be mail that was sent to Robert Baker by the defendant.
Yes.
Actually, that calls for a conclusion.
Sustain.
And can you tell us, what is it that we see here?
It's I don't really want to call it a love letter. It's just a letter
It's a
talking
smut
about
letter.
somebody being sexy, looking sexy.
Okay, whoa. I want to make sure we read it. I found another ass pics for your wall decoration. Ha ha. Sandy A's. I got those same creases on my bottom now, except I got a lily white butt. And the white shirt dress reminds me of mine. Good times in that shirt dress. Enjoy. I want to see those tees. Petite and firm with exy ipples, but come on, that sandy blank butt is one of the nicest I've seen. Hot. Whoo! Nothing like seeing smut
Talks
letters
about
in jail.
a sexy sandy ass, and that
You're
she got
gonna
those
read it word
creases
for
on her
word.
bottom,
I'm trying not to get demonetized.
and then attached, or
Thanks,
in addition
ma'am.
to that, magazine, pictures, correct?
Correct.
And a photograph
She's
of
like,
a
I've
woman's
never seen
buttocks
that.
that appear to have sand on them.
Yes.
What you
And
talking about, Willis?
within the same envelope,
Okay.
on lined
Pause.
paper,
I don't know how that crap got passed and got sent from one inmate to another, because let me tell you, or I mean, those can't be sent to inmates. Those kind of pics, most places do not get to inmates.
a heart, and what does it say?
Ride or die.
And attached to that, does there appear to be an article regarding sexual positions
Yes.
based on the
Matthew?
title?
Yes.
Another photograph of a woman's buttocks, and looking at the next item, does this appear to be
We have
a
people trying
happy
to sell us
birthday
homemade
message?
popcorn.
Yes, it does.
She's begging. She's got her hands crossed and everything.
And at the bottom, is there a signature?
No.
Forever, baby, forever with a heart.
Yes, but no signature.
And if I turn it over, does the letter indicate that,
You knew
as she
I am.
explained in her other letter, he found his ride or die,
He's gonna
nobody
take
else, no matter what.
my son's buying popcorn
Yes.
from a kid.
And again, looking at the language here in the writing, I found mine and you, proven, tested, tried and true, always 100%, always resolute. Some of those phrases, always 100, always resolute, was that the same language that was utilized by the defendant and Robert Baker in communicating with one another?
Objection, speculation.
So we're ruled.
Yes. In overhears and stuff, I remember that exact language readily.
And then at the bottom, it looks like a drawing of hands with a lipstick
Oh.
for a mouth, and then
Oh my God.
correct?
It's such
Yes.
a
And what does that
hoe.
say? It says insert dick here,
Thank you.
correct?
Yes.
Okay. And another document, handwritten note in the same type of writing.
It's free
Again,
popcorn.
have
You
you
got
seen
flavor.
this type of language used in numerous messages or jail kites letters from the defendant to Robert Baker?
Yes.
Okay. And here again, using the phrase
Okay.
calling Mr. Baker baby, as we saw in the other letter, so proud, baby, so proud and grateful for all of you.
You won't
You're
believe
my
the smut
And
this
and
woman
my beginning.
guy in jail.
Even when I lose, I'm winning.
Put lips on it.
The bad song. Can't help but cry when I hear our song. Fuck, I miss my man, my savior, my sexy beast, my husband. Correct?
yes.
And then at the bottom, again, under a similar lipstick kiss, it looks like some more writing. Is that right?
Yes.
And then attached
I feel like I just got home from the carnival.
to this, within
Hi, Court
this
TV.
envelope is a drawing. You see this?
Welcome,
I have.
TV.
I recovered it.
This.
So looking at the top,
What?
does this also
Thank you for joining us,
appear to
Court
be
TV.
the
Thank you.
drawing consistent with
I'm not interpreting because we don't have anyone to interpret.
other
Oh,
letters,
Lord.
jail again, letters that you've seen drafted by the defendant to Robert Baker?
Okay, guys,
Yes.
there goes our
And
monetization.
the female who's
Normal.
sitting naked at a bar drinking, there appears to be some sort of lower back tattoo.
Yes.
What is that?
RLB.
What does RLB stand for?
Robert Louis Baker.
Oh, my God.
Okay. And there also appear to be.
I want to welcome Court TV. I really want to say, I've said it before, but I'll say it now. Appreciate you so much, Court TV. Without you, we couldn't be doing this. You are fabulous. We appreciate everything you do and all of the hard work that you go through to bring us these trials. We bless you, we thank you, and we give you kudos and credit where credit is due. Back to the show. I know it's like she is in her 40s, y'all, acting like a ex-addict, 20-year-old nymphomaniac. 20-year-old nymphomaniac is what she's acting like. I mean, it doesn't matter if I'm monetized now or not because they've said so much stuff. Well, what can I do? I'm 6 hours into this, but it is so disgusting. Oh, no, we always thank you, Court TV. You don't see it, but we do. And anything we share, we put the runner down below. Let's see if I have it, just so you know what we do. Because I'm very, 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 very appreciate. We put this up anytime we share anything of yours, just so people know. But there is no way in God's green earth. I can't imagine acting like this as a mother. What are you teaching your daughter? She's just nothing but trash. I said it. Now we got to get back or we'll never finish today.
A name written
And I gotta
on
finish
the
this.
umbrella where the female
You
is drinking.
Yes. Maestros.
And if we look at the bottom,
A granny hussy. Oh, somebody called her a granny hussy.
does there also appear to be more?
Yes.
Granny ho.
Yes. It says, waiting at the bar for my baby. Come meet me in my dreams.
And we
Another
wonder why
drawing.
our children are the way they are.
What do we see here?
Well,
She
it's a
has
drawing
been
of a
taking a
woman
lot of
in,
notes. What is there to take
like
notes about
a
when you're
two-piece
looking at
bathing suit, her
yourself?
hands in the front of the bathing suit, some tattoos or nylon, I'm not sure what that's supposed to be. Some sort of a covering of the eyes. There's a tattoo above the groin area that says master.
Oh,
And
she has
there's
a
a necklace that she's wearing with an R.
well,
Robert,
you don't know that for sure, Candace, but
that
you're nine.
consistent
I
with
would
the
say
first letter
80%
of
right on that.
Robert
Who
Baker,
knows?
just like we
Her
saw
daughter may have
lower
walked in
back.
and caught her doing something.
So rule.
She
Yes.
wasn't really secretive about it.
The next one, another drawing, looks like the hands are
Thank you for
pointed
stopping by
to
Court TV.
10 o'clock.
I appreciate
Yes.
the support.
And above that, you also see Robert Baker's initials.
Yes, RB.
Did you often, as we talked about the codes that the defendant and Baker would use
Oh my God.
in their jail communications, whether it be by letter or in their phone calls where they were able to talk to each other, did the time
Oh, I
10
want to see
p.m. or
those.
10
I want
o'clock
to hear
come
those.
up numerous times?
Yes.
In what aspect?
It was, they talked about in their jail mail and calls that they would always pause at 10 o'clock to think about each other.
Oh, jail
And the
romance. What
last
can I
page
say?
says there appeared to be again another handwritten letter,
What can I say?
front and back. That ends with happy holidays for the rest of this life and the next. More than love, your SMHLM.
Yes.
What?
Any idea what any of that means?
SHMLN?
Time, let's take our afternoon recess for 15 minutes. The admonition does apply.
I want to hear that again. I need to hear that again.
HLM.
Yes.
Any idea what any of that means?
No.
HLM. Next, more than love, your SMHLM.
Yes.
Any idea what any of that means?
No.
Time, let's take our afternoon recess for 15 minutes. The admonition does apply.
Okay, that's interesting. We got a little bit of a leeway. Okay, guys. The smut has hit. It got entertaining. This is what we live for, the entertaining, right? OMG. It got I feel dirty. I want to wash. Here. This is as close as I can go do. Oh my God, did that skanky. What do y'all think? OMG. Skanky little hussy. I want to find out something. She's 52. She was 49 when she was charged. You're telling me that this is a granny hoe? Oh, that makes it worse. She's just a year younger than me. Oh, I'm not kidding. I'm not kidding. It is so disgusting, y'all. You ought to see me. I'm just like, I am like utterly disgusted by this. I cannot believe the granny hoe. She's got a new nickname, Granny Hoe. But it's great if you have a good body at that age. I commend you. But you have to be a nymphomaniac at this point. It doesn't matter with my, yeah, they're gonna stop me from getting anything. Oh, you guys. Okay. So she isn't, and she's stupid. She's a stupid one at that because every phone call in jail is monitored, video and or other, right? So why would you be showing your daughter or whoever that was a, a jail tattoo? Because you get in trouble for getting a jail tattoo. And if the jail tattoo artist gets caught, you are not only going to get in trouble by them, but you're going to be in trouble by everybody else because nobody likes a snitch and nobody likes a what they call the jail tattoo artist to get in trouble because then it stops it from everybody. So I just wonder what happened, if anything. What happened with anything? But my gosh, this is. Uh, uh, Candace, are you as disgusted as I am by her behavior? It's pretty disgusting. I mean, at her age, well, I don't know, y'all. It's one thing if you want to be kinky with your husband or whatever in the bedroom, but to become at her age, basically, she was selling herself out, doing all the inappropriate pictures, doing everything a stupid young kid would do. It is appalling. And I mean, I'm so grateful I have kids. I don't have to worry about that kind of stuff. My daughter's been dating the same guy since high school. They're getting ready to get engaged. She's a good girl. I'm not saying that she may not have done something, but dang. I know court TV, this trial, did you hear the judge? Many times. Well, the first couple of weeks, he was like, y'all, at the rate we're moving, we're going to be here till Christmas. We might as well get to know each other. Now he's saying, at the rate this is going, we're going to be here for 2 Christmases and then some. I don't understand this. And the problem is the attorneys take forever. Yes, I'm doing it. I'm saying it. I'm being snotty. They take forever. They're sitting there and uh, they're not organized. I have never seen do that. Just do this. I have not seen attorneys get away with so much dead time in trial between questions. It's crazy. This is about as long as Reed and Daybell. Well, okay, Court TV. Question. How long do you think Reed's going to be this time? You want to gander or guess? We'll put up a guess. Guess. Let me know. I think it's going to be shorter. I don't think it's going to be longer. I think it's going to be shorter. And the reason why is because we're not going to have to hear from 30 witnesses how cold it was, how much snow it was, how fast was the wind blowing. Because they're trying to bring in a meteorologist who has no scientific expert witnesses skills on how the ground freezes and how hard it is and at what depth and what temperature will it bust ahead. I don't know. We're just going crazy on it. But question, do you think that the Karen Reed trial is going to take a longer or shorter? Yeah, and also I think, dagnabbit, I think it's going to be shorter because they also kind of having a second run at it. I believe, that they know what worked, what doesn't work, what they could leave out, what they should leave out. It just depends. It really depends. But I will tell you that I'm a little bit worried because we just went over, for those of you who do not know, some more documents have dropped. And we just went through the Commonwealth's opposition to the writ of habeas. Yeah, we did. Court TV, put the thumbs up if you say the words ILIKED in the comments. We have a gift at the end of the month that we're drawing, and you may win an entry. Love to bless you. But I am 35 days. That's right. There is no holidays in April. Oh, that's going to help. Yeah, the high tables and the band. Yeah, I know. Bet the band really appreciated the shout out. Now they're the famous Karen Reed band. But no. I'm just a little bit worried that this I'm worried for her because she has not had any luck when it comes to anything with this court. And that's what's concerning me. Out of all of those motions that they went through those 2 days, she has won none of them. None of them. And they agreed on some of them, but they've won none of them. That is an issue. No, they didn't have to say their name. All people would have to do is call up to the bar and say, "Hey, what band was playing that night? I want to come see them." Oh, dad nabbit. I keep stabbing myself. Yeah, I'm beating. I am so tight on a deadline, y'all. It sucks, but you do what you got to do. But no, I have all the confidence that her lawyers are good and all of that. Yeah, they only had 2 agreements and nothing else did they win. And I was like, some of those I thought they should have won, but I'm not the judge. Put thumbs up if you think I could be a better judge than Canoni. Boy, this is going to put y'all on the spot. Do you think I could do a better job than Canone? Auntie Bev? I really don't like calling her judge. Oh, go on, Miss. I know Court TV. I know you're busy. You're showing love and spreading it all over the world. Thanks for the reach out. Thanks for including me in on that possible project. You guys are awesome. And we look forward to sharing more of your content in the near future. Thank you for your love and support. Have a great weekend. It's almost weekend. It's a Thursday. Hey, Candace. I love the little lovin'. But no, this woman is a oh, that was supposed to be a thumbs up. Don't worry about it. It's cute. It's cute. Bye, Court TV. Give everybody our love. It's been a while since Court TV's hopped on with us. Thank you so much. We appreciate it. Or maybe they've been lurking and I didn't know it, which is very possible. Which is possible. For those of you, Vinny has some new video footage I wanted to share tonight. I have got to get some things done around here, so we'll see how I'm feeling. I've got to when this is over, I'm going to stop, but I'm thinking about coming back live later on tonight. I'll come back live. And because it's got some new video footage from that judge that was unalived by his sheriff, the sheriff, no longer sheriff. So there's some interesting things churning in that case. I am trying to find a way to, and I got to call the court system in San Antonio. I got to find a way to start getting court documents for the Simpson trial, where he's being accused of unaliving his wife, but there's no body. And that's happening in the San Antonio federal court system. I'm trying to get what I can, but it's federal, so there you go. I would like to at least be able to keep up with the actual court schedule, so I'm going to try and be researching all of that. Because I want to go to that, even if it's just the motion hearings and things like that. Tomorrow I will be dropping the announcement, but I'm going to be Sunday Night Live. We'll have to Miss Tanika. There is a new video, sunny day. New video. And of course, Vinny Politan from Court TV is the only place I've seen it. And I think I want us to watch that video and support him. But y'all, it's something. Something. Oh. I have sewn the needle through my finger and the thread and didn't even realize it because it was such a tight, it was barely caught. Mm. When is this? 6 p.m. tonight, 6:15. Okay. I will do the Vinnie Politan at 6:15 p.m. tonight. So you guys can see that. Vinny's so cool. Or Court TV's doing it tonight. I assume it's what Vinny had done. But we will be. Oh, saw a little flasher getting ready to come back. By the way, yesterday was. Guess whose birthday was yesterday, y'all? We got to do a birthday. It was a very special birthday yesterday. Let's do the birthday.
Happy birthday to you. Happy birthday to you. Happy
birthday, Karen Reed. Happy birthday to you. Happy birthday
to you. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you. Happy birthday to you. Happy birthday
Ryan.
to you.
That was taken with her eating dinner yesterday. Was her birthday.
Happy birthday.
And you know what? With Karen Reed's life the way it is, she deserves all the happy birthday wishes she can get. So, Karen Reed, you will never know we wished you a happy birthday, but we did. Happy birthday, Miss Karen Reed. Praying it was a good one. Pray that you enjoyed time with your family and your friends, and hopefully you were well blessed. We're praying for you now as you're going through this hell. Somebody on Tanika, speaking of Tanika, I did a live on Tanika's, if you didn't know. I wanted her to get all the views because it was her live. That said, I will be dropping it in my videos tonight. A copy of it. She gave me a copy of it, so I will drop it in tonight. So if y'all didn't catch it over there, you can catch it over here. I think it's been several days. So I just wanted to make sure that, I didn't rain on her parade because that was her show. So, but I'll be dropping it in the next tonight or tomorrow. But, someone made a comment about me being very biased, and I'm like, I was not biased when I started watching. In fact, I was against her when I started watching the trial. I thought she was drunk and hit him. She should go to jail for drunk driving. But once
To the exterior
I
envelope.
started seeing the evidence, that changed. Some people don't like it, but that's okay. You can be biased on your side, I'll be biased on mine, and we can politely disagree.
Your Honor, I have another envelope. This one's an LAPD evidence envelope that bears the victim's name, Fabio Sementilli.
Okay, get the mic. Come on.
The description
I
is
didn't change
in
anything.
Papers, items 168 to 173. There is a property report attached.
She's not staying
May
near
it
the
and its
mic.
contents be
She's
marked
moving
as
around.
equals 226.
Yes.
Thank you.
Yeah, she is moving around a wee bit. Sorry, can't do anything about them. See, this is what I'm talking about. This is why this is taking forever. There is so much dead time.
Detective, show me what's been
Everything moves.
marked
They're all
as
talking and moving at a snail's pace.
equals 226. Do you recognize what you see there?
Yes,
And what is that?
it's a property report on the front, but evidence envelope containing, it says underwear. I don't know if there's underwear in here, but and then
Ew.
miscellaneous papers and news articles.
Okay.
She mailed him
This
her
is,
underwear
again,
from
one of
prison.
the items
Yeah.
that you reviewed with respect to evidence book to this case.
She looks
In this
confused.
case by Detective Byers.
Yes,
Did you
Josh
work?
Byers.
Yes. Did you work with Detective Byers and Detective Farrell when you were at Robbery Homicide Division for many years?
For many years, yes.
And did you meet with them and discuss with them your investigation when you retired and they took over the case as the third set of investigating officers?
Yes, graciously they did.
Can you open this envelope and again remove the items inside the items?
Okay, within the envelope, there's 1, 2, 3, 4, 5, 6
6 smaller envelopes.
manila envelopes. Each one is corresponding to the item number that Detective Byers put on his report.
All right. Item 168.
Says miscellaneous papers.
So if we put them in order, do the actual envelopes inside range from 168 to 173?
Correct.
Okay. If we turn over the document, the property report on the exterior of the envelope, does that run through 173?
Correct.
Okay. And let's start with the first envelope, 168. Can you open that and tell us what's inside?
It's miscellaneous papers. It appears to be some sort of a letter or notes.
Okay. Handwritten in pencil?
Yes, handwritten in pencil.
And is it typical that jail mail is always written in pencil because that's what the sheriff provides?
Yes, and the paper is usually very distinct too. It's that gray paper,
Lined paper,
gray lined paper.
like notebook paper?
Yeah, it reminds me of the stuff I had in like kindergarten.
Okay.
The cheap stuff.
And this,
And they pay
you said it was
a
4
pretty penny
pages.
for it. It's not free. We have to pay for that.
in length?
Yes, it's 4 pages in length.
Okay. And were these recovered from Mr. Baker's cell?
Yes, when Mr. Baker was at the North County Correctional Facility, which is in Castaic.
NCCF?
Yes.
And what date?
On August 14th, 2017 at 10 in the morning.
Okay. You could return that to its envelope. And if you could open the next.
She didn't know all her mail was going to get confiscated.
This is a newspaper article. I'm sorry, there's another page.
Hey, everyone. Hey, Miss Morales. How's you doing, girl?
Looking at the two pieces you just handed me from
We had a
169,
surprise
are
visitor
these
today.
newspaper articles relating to the not guilty pleas of the defendant and Robert Baker relating to the murder of Monica Sementilli?
Yes.
Okay. You can return these to the envelope.
You done with that?
Move on to 170.
I thought she said they were panties. I'm surprised they didn't pull them out.
This is jail, typical what a jail mail envelope looks like.
Jail
Since
panties.
It's been
Cool.
inspected by somebody at the sheriff's department.
And
It's,
that's based on a stamp in red on the exterior of the envelope?
yes, and it, see if we can see here. It definitely comes from the women's facility because the women's facility is in Linwood, although the sender is off, but it's to Robert Baker with his booking number. And then also what appears to be a drawing of a typical sort of cell block.
How do you know that?
It's well, number one, I've been to a county jail numerous times, and the drawing with the doors looks very similar to the jails that I visited. And then there's double cot beds, the toilet next to the cot beds, and then there's 3300, which is kind of the cell block number.
So someone drew an exhibit E for her.
That appears to be a hand-drawn photo, hand-drawn drawing,
Yes,
this here.
correct.
Looking at the exterior of the envelope, when we spoke earlier about booking numbers or pins, would this be the booking number for Robert Baker?
Yes, that's correct.
The address at the North County Correctional Facility
Yes,
coming from CRDF, Linwood Jail,
yes,
the women's jail?
correct.
And is that the same location you went to when you obtained the DNA reference sample from the defendant that I believe you told us you booked as item 201?
Correct.
And if we look at the letter inside, does it appear to be front and back of 2 pages? So therefore, we're talking about 4 handwritten pages in total.
Yes.
And does it start out at the top of the first page with "How's my man"?
It does.
And if we look at page 4, in
Wait a
the
minute.
center
They're saying,
of the
just FYI, on Gene Hackman, they're saying they could have been deceased for a week to 2 weeks. That's sad.
This piece of paper, uh, coded, letters, OMM. Do you know what that stands for?
I don't know what the OMM stands for.
On my mind. Have you heard that before?
On my
I
mind,
have heard
His
that.
name.
How about LOML?
The love of my life.
100, we talked about the other letter I showed you earlier where it said 100% or 100,
Correct,
a certain time.
correct,
Again, the phrase ride or die.
yes,
And then the phrase be smart and be strong, baby.
yes,
Also, I'm in love.
can you be?
Nothing can break me now.
correct,
And at the bottom, hope to hear from you too. See you tonight at 9 p.m. LYVM.
love you very much.
Look at him
Mrs.
laughing.
Yes.
Why are you
Yes,
laughing?
I miss my sake and oysters, and then that same phrase that we saw in the last letter,
Yes,
and always OMM with a heart.
yes,
Y'all. I would never write letters to my ex in jail. I wouldn't do it. Not unless I had to.
Looking at the next envelope. $171.
171, again, this is J.O. Mail. This is to Robert Baker. It has the inspected red stamp, has his booking number, and the sender says it's Nisha Hire, Hayer, Nisha, Nishia, at the Women's Detention Center.
Again in Linwood,
Yes,
same location where you collected a buccal swab, reference samples from the defendant.
yes,
Moving back for a moment to the last letter that I showed you that was 4 pages.
Yeah.
On page 4, do you see here where it says resolute, comma, protocol?
yes,
And beneath that, I fucking love you, babe.
yes.
I love you, babe.
Well, I'm gonna inject that.
Y'all, this is just
Do you know what is meant by protocol in these letters based on your review of many of them?
Thing, there's been testimony before by others.
All right, showing you the first document. Does this appear to be a drawing next to a letter?
Yes,
And again, is this a typical jail kite or letter?
yes, Jail Mail.
At the bottom, once again, do you see where it says here, I am as strong as ever and will not lose faith, that we will overcome and live the way we want. I love you very much. Manja, Kate forever, Mrs. Baker.
Yes. And
On the front, do you also see, once again, on the front where the picture is, that same code, LOML with a heart?
love of my life.
she didn't grieve very long, did she?
Showing you another letter, 4 at the very top on page 1, you see again that phrase LOML?
Yes.
Okay, what's the deal with this? Why are we going down this road? Where are we going?
At
What
the
are you doing?
bottom of page 3, you see here it says, don't forget our love is our bond, it's unbreakable, and then that same phrase, Lua, MB.
Yes.
Oh, I speak out loud to you every night at 9 p.m. I love you. Can somehow sense. Oh, here. I can only hope that.
MB stand for.
Monica Baker or Mrs. Baker.
And on the back, you again see a
I'm reading Kills by Patricia Caldwell.
same type of code,
June.
OMM,
LOML LYVM 9 p.m.
and at the bottom, you also see the signature again, MB. I'm sorry.
Yes.
Again, on the next page, looks like
And he's
there's
making
some drawings
puzzles
at
for
the
it.
top of, bless you. Looks like it says it's dated July 1st, 2017. There's some sunshine, maybe a palm tree. And then halfway down, you see, again, those same codes.
Yes. And I believe on the top and in the previous letter, also the I do. It was at the bottom of the previous
Yes.
one that you had. And
Just above
yes,
the Monica Baker signature.
right.
And again, at the bottom, again, that same signature for Monica Baker.
Yes.
And so would this be an example of sending jail mail, or what's referred to as kites, as we've heard, through other inmates' booking numbers to try to get around
There you
any
go.
order that you're trying to copy mail belonging to a particular inmate's booking number by using this type of procedure?
Ding, ding,
Yes.
ding,
And
ding.
if had there not been a cell search,
Okay, here's the problem, y'all. She's not supposed to be sending him mail. But what she can do is say, okay, inmate Jane can't send mail to her convicted felon or co-conspirator or whatever. So what do? They swap mail and send it for each other to that inmate.
search on this one, that's a perfect example. We never would have found this letter because it didn't go through the traditional protocol with Monica's booking number, so it would never came in and been flagged.
So because the booking number on the top is from a booking number relating to a different inmate, this particular letter would never have been copied. However, as you said, you did a cell search on this particular day.
Correct.
Or Detective Fires did.
Correct.
So she's breaking the rules. Guess what? She can get in trouble for that now. Oh yeah. That's a major infraction. Major.
There's gotta be
In some ways, that's worse than
Moving on to number
for
I've
somebody.
been with that in that envelope.
172.
I think this was in all together and I just forgot to pull it out.
Okay. And it appears to be an envelope with a single page drawing, is that right?
Yes, that's item 172.
And this phrase here, synced and linked, is that a phrase that came up in jail mail as well as in conversations that were recorded in the jailhouse lockup that we'll listen to next week.
Multiple times.
And again, a drawing, and halfway down, pointing to the male individual's buttocks, does it indicate property of Monica Baker?
It does.
And then on the finger, just like we saw in one of the other drawings with respect to tattoos and things like that, initials RB.
That's correct.
Okay, this is dated August 6th.
She's pulling a Sarah Boone.
Yes.
And then at the very bottom, Payne's baby.
Yes.
Is that date 17?
Doesn't have a year. And the last envelope.
The last envelope is number 173. And again, it's, well, it's an envelope. Doesn't have any markings on the outside, but it's numerous letters and papers inside. Correct.
The first one indicates it's 10 pages in length, and it appears to have handwriting on both sides of the paper.
Yes.
At the bottom of the second page, on the back, do we see that same phrase, LOML?
Yes.
Mrs. Baker?
Correct.
With respect to the second set of handwritten docs, once again, we see that same phrase, but this time with the defendant's first name, Monica.
Yes.
And the back of the next page, again, those same type of codes. This one, LUVM,
Love you very much.
R or D,
Ride or die.
100, and then the name Monica Baker.
Correct.
Boy, she got a lot of mail out. I'm shocked that they didn't catch it sooner. But they wouldn't have until they did a cell search.
And then multiple pages regarding handwritten letters. And at the bottom of the next page, again, on the signature line, always OMM, always Robert, I love you, 9 p.m., and then your woman always.
Correct.
And another set of writings. Again, at the top, we are definitely synced.
Yes.
That same phrase we talked about a moment ago.
Correct.
And at the very bottom of the last page, again, always OMM, always 100 with all of my fiber, Mrs. Baker, with that same ruach.
Correct.
All right, what are y'all thinking? Does this seem high schoolish to you? I don't know. It's been so long since I've been madly in love. But it just, some of it just seems so childish. I'm struggling with it. It looks like little love notes my daughter could have been writing her boyfriend in high school.
Those go into this envelope and then-
But then again, when you're confined, you do all kind of crazy, stupid
First
stuff.
grouping to the exterior packaging. And
But I could not imagine sitting there and having a child sitting behind me, or family watching this and seeing
a
this.
property
I'm
report
disgusted.
stapled to the exterior. It says in red pen, number 209 to 210. May it and its contents be marked, please, as People's 227.
It may.
Wow, I hadn't heard from his voice in a while. Almost forgot what it sounded like.
Showing you exhibit 227. Do you recognize what you see here?
Yes, it's a LAPD evidence envelope.
Oh,
It actually
good.
has my name
Motor has
sticking out,
actual
probably
gloves
right.
on.
Yes. And if you,
No, I booked the originals. I booked it after retrieving it from the sheriff's.
okay. And who did you retrieve it from? The sheriff's department?
From the sheriff's department, and they had it in their evidence.
Okay. So you rebooked it from sheriff's back to LAPD property under this case number
Correct.
because it was evidence that was recovered by the sheriff's
That is correct. I believe at one of the court facilities.
here.
Yes.
And looking at the evidence envelope inside,
Yes.
does that confirm what you just said?
Yes. It's a 1 manila envelope containing several pieces of paperwork.
And does this,
Court Services Central, Bureau Central, and it's booked by D.
Schackenberg, Dustin Schackenberg?
With a serial number of 532. And it was booked on June 28, 2008.
18.
Yes.
Thank you. And this is evidence again that you recovered from the sheriff's department and then booked in under this case number.
Correct.
Okay, thank you. And I'm going to return that sheriff's envelope into your exterior packaging, and we'll deal with that tomorrow with the sheriff's department.
Oh, it looks like they'll be doing it tomorrow too.
For a moment to People's 226, looking at the third page.
Somebody she doesn't have a whole lot of gray hair, that's for sure. She's got some. Doesn't have a whole lot. I thought she was younger than that.
About
Yes.
10 lines down, do you see where it says, what I'm pointing to here?
Yes.
Anybody think she was living a midlife
I
crisis?
stuck to protocol, admitted to love affair of about a year.
If I ever was in jail or prison, I wouldn't write a thing. I wouldn't say a thing that was being recorded or could be copied. Keep your mouth shut. Speak to people about your case to your attorney
Returning
in the
ones
room
that
that's
I've
not
given you, and I think
recorded.
this is one of the prior ones.
I'm waiting for the panties. There's underwear somewhere. Unless they're not going to show it. Jail underwear. Ooh.
the next thing I have is, some recorded jail calls. I don't know if the court wants to start that now, or if you want to break at this point, and we'll continue with that later.
As I understand it, we're going to interrupt Detective Roberts' testimony tomorrow and have other witnesses testify. Is that correct?
That's correct.
This is a good time to interrupt the testimony then.
Okay.
All right, so we're going to be in adjournment until tomorrow at 9 o'clock. The admin advised not to discuss this case among yourselves with anyone else. A form of expressing opinion for the cause is finally submitted to you. As you heard, we're going to interrupt Detective Roberts' testimony for tomorrow. So have a good evening. See you tomorrow at 9.
Well, they say tomorrow at 9, but every day they've started 30 minutes to an hour late. So I'm just gonna put this down. We're gonna wrap up. I got some cleaning to do. I got some things to do. And then I'll come back later tonight. Remove and big and me. Get rid of that. Clear everything out. I've got too much stuff I got to edit. So you guys have been so absolutely amazing. I love and adore you. You've been great. Appreciate all of you. Here is the I liked. Okay, I only have 8 likes in. Come on now. Come on. Hurry up. If you haven't said I liked and pushed the like button, we got 27 likes, but only 8 registered. Hurry up and get your I liked in. Very high schoolish. Very, very high schoolish. Go ahead and get it in the next minute or so, because I'm going to do the drawing. Let me get it up on the screen. All righty, y'all. No more, no mas. Here we go. Toxic! Yay, we're going to do one more. Hello, it Brit. You've also got in, so yay. Okay, I'll put you guys in. All right, guys, I adore you. You're awesome. It was an interesting day. I did not think we were going to get to smut today. That wasn't on my bingo card. Again, I thank all of you for watching, but a special shout out to Trial Court, Court TV. Thank you so much for taking the time out of your busy day to come over and share some love. So, see y'all tomorrow, 11 o'clock Central Time, 9 a.m. West Coast, and 10 a.m. on the East Coast. Have a great night. I may be here. Keep your eye out. I may come in tonight. Let's just see if I get my things done in time. And I'll be comfy. We're going to be comfy. All right, guys. Blessings. Miigwech. Have a great day. See you tomorrow. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.